Megan Fox has the story.
Megan Fox.
Megan Fox.
Megan Fox.
Megan Fox. Megan Fox, a national journalist.
Mastodon. I will never be able to say that out loud.
It feels like the Flintstones live there.
It does.
Well, don't trust women. I think you just touched on that with your last. That's what they brought. We're going to have to bring back chaperones.
Jesus, no.
Just careful. Stop! Right. Ooh. Hard right.
How did you screw up a stove, Megan? You're a woman. I thought that was baked into you, like at the genetic level, how to operate kitchen equipment.
And honestly, Megan, if you don't like it, I'm sorry. I've been very nice to you.
You get Dino hanging out outside chewing on a large bone. I highly recommend being targeted by the New York Times and Rolling Stone for weight loss. And I'd say, keep it coming. I need to lose 20 more. Please, keep it coming.
Explain to me, Megan, why did this country not have a holiday once a year? That's the time you vote. If you don't show up and vote, up your ass. You don't get another chance. You don't get, I don't care if you're in the hospital. Crawl to the state, crawl there. But that's it, one day, 12 hours, and then you're done. And you count them that day, and that night you know who the hell won.
I will eat you alive. You want to tangle? You want to go?
The only thing going through my head is, what are you going to do when Megan Fox runs wild on you, brother?
He made a deal with the devil. She's the devil.
He wants that.
Oh, God. Gross! Oh! All right. Penalty box for slug. Yep.
Of a mile.
Are you ready to behave yourself now, slug?
This frustrating rep.
Are you ready to behave yourself? Repossessed puppies. I'm hiding Pork Chop. Have you seen his little Pork Chop? Oh my God, Pork Chop is the cutest.
That sounds bad.
Have you seen it?
Pork. It's pork.
Though you may be tempted, do not contact any person or persons mentioned on this stream. Do not even think about contacting anyone who may be the topic of the daily news. If you should do that, the host will question your IQ, possibly call you names, and mock you for disobeying these basic rules of decency.
Hello, everybody. Welcome back to the program. It's me, Megan Fox. What's wrong with my camera? There's something wrong with this angle. I don't love it. And I got to get new headphones because my left ear is cutting out already. I don't like it. Okay. We have a lot to get to today, by the way. Hello, everybody in the chat. Vice, baby, good to see you. By the way, Connor did get his play button, his dad's play button. So we are all very excited about that. If you want to go and watch his stream where he unboxes it, it is there. Thanks for the super chat, Jill. Thanks for the $5. Says much love. Well, much love back to you as well. I'm going to try and keep up on super chats today so I don't have to scroll up. I always have to scroll up in Streamlabs in order to see it, which is annoying. It's time for me to wash my hair. I can tell it's not really falling right today. I don't like it. I'm not having a good hair day. I think I'll put it up. But hopefully we won't have to focus on my hair too much because there are things to watch. We have 2 hearings to get through. We have the Karen Reed, the motion to dismiss hearing to go over I'm not going to go over the whole thing. It's like 5 hours long. It's insane. But we are going to go over the recaps. See, this is why I don't wear eye makeup. I don't like it. I put some on today because I felt like I was looking pale. But now on camera, it's like my eyes just look small and I don't like it. I don't like it. Not doing. You will not see me in eye makeup very often. I just think it makes me look weird. Okay. So anyway, we have to start with the Karen Reed hearing. That's what we're going to do. And there were some bombshells in this hearing. We have a Bitchy Bev bingo card. I have pinned it to the top of the chat. Here's what we have today. We have, hold on, let me get over there. We have a free space, obviously, we can start with. We've got shock and horror, bad hair, parking cars, Bev gets on high horse, Trooper Proctor, who is definitely going to make an appearance more than once as far as talking about him. Sallyport, satirist. Now we have 2 hearings to go over because we're going to get to Turtleboy too. So this is like a combined card. Bev interrupts defense. Bev sigh. Doctored video. Mr. Carney exercises free speech. Witness intimidation. Ooh, what's that sticker showing up on the screen? That's fun. What is that? Is it a gifted memberships? That's so cool. How come look how it shows up? That's so fun. Thank you so much. IT Goatee is a member. Haven't you always been a member? Welcome to the Fox Den again. Maybe you got a gifted membership. That's fun. Oh yeah, these are the people who got gifted memberships. I love it. Hey Joe, awesome. Congrats. All right, we've got Bev interrupts defense, Bev side, doctored video, witness intimidation, police sirens, Brennan lies, Bev sigh, again, I put it in here like 5 times, yells in Boston, silly security cam, Bev sigh, Brennan bombs, bitch Bev, new info about video, Bev Brennan love fest, Bev sigh, and bitch babies. And yes, I'm assuring you we will get to all those things. Thank you to Gone to the Dogs for the 5 gifted memberships. We appreciate those very much. And Julie, thanks for the 5, says, will you be covering this trial live? Trying to decide whose coverage I will watch, and you're my number 1 choice. I will try. I am going to try to cover it live. I will be gone in April, though, for spring break. And I believe this starts April, what? Isn't it? Doesn't it start April, the first week of April? I will be gone. Let me look at my calendar. We will be gone on a spring break trip for like a week. 14th, starting on the 14th. So I doubt I'm going to be able to cover it live, or at least I'll have to skip a week. But I mean, how many weeks is this going on for? It's going to be a while, right? I'm going to try, but I do have spring break to go on. So, all right, let's get over to the first hearing. We are going to start now. I'm skipping the beginning because, listen, in the beginning of the hearing, it is really the defense is going to go with their problem with Lieutenant Fanning, who they thought interfered with a juror. I'm telling you, that argument is going nowhere, and there's no point in going over it. She is not going to. The judge is already like, this is a lie. This is not true. Lieutenant Fanning did nothing wrong. I disagree. I think we all disagree that he should not have been the one, when he was involved in the investigation, to be reporting on jurors. And making false accusations against jurors. The jurors said that they didn't talk about it at lunch, and this guy said that he overheard a juror talking about the case at lunch. The juror says, no, I didn't, and the juror just happened to be a pro Karen Reed juror. But this is going nowhere. This argument is going nowhere, so we are skipping it because I'm telling you, judge is not going to. She's not buying it. She yells at the defense, tells them they're lying. It's no good. Okay, so we're skipping over that. We're going to start right here where AJ wants, I think that's his name, right? I can't remember their names. I get Yannetti and the other one, Jackson, confused. But anyway, I think it's Jackson who's speaking, and he says he wants Yannetti to speak because he was invoked. But of course, the judge ain't having it. Here we go. Barnyard Sally, thanks for the 5. You are having a good hair day today. Oh, thanks. I don't love it. It's definitely, we're getting to wash day. It feels like it's just sitting on my head. I don't know. It's like getting smushed down, but thank you. I'm glad you like it. All right, here we go.
Thank you for that. The court invoked Mr. Yannetti and said, as local counsel, he knows this not to be true. To at least address the court. As the court said yesterday, when we file something, we file it on behalf of everyone, including Mr. Yannetti. So if the court would allow Mr. Unetti to explain what his experience is, that may elucidate on this issue.
If we have time later, go on with your argument.
Nope. Bev's not going to allow it. She's not going to allow him to respond to the charges that he should have known or he did know or blah, blah, blah. Nope. Not going to happen. Oh, and by the way, I have my blood pressure cuff here handy. I'm monitoring my blood pressure because it's high, and I'm sure that this trial, this hearing will not do anything to lower it, but we'll see. If I get really worked up, I may have to take a reading.
I'm happy to, Your Honor, and thank you for giving me the opportunity. The cumulative discovery misconduct by the Commonwealth, as laid out in our moving papers, through their agents has been both egregious and pervasive. We've outlined most of these issues in our moving papers, all of these issues in our moving papers, but I want to concentrate my argument for the court this afternoon on the exculpatory Sallyport videos.
Police sirens. You can get over to your bingo card. Here come the police sirens. We got that right off the bat. Where is my bingo card? There it is. Police sirens. All right. There you go. So now we have free space and we have police sirens.
I'm not waiving any of our arguments in the moving papers, but in the interest of time and focus, I think it bears upon the court at this point to consider most prominently the Sallyport issue, or the Sallyport video issue. The Commonwealth, to start off with, two facts that are true. The Commonwealth cannot deny the untimely disclosure of critical exculpatory evidence. They cannot and they will not deny that untimely disclosure. And they also cannot deny that critical evidence was intentionally, not by some sort of mishap, but intentionally was withheld from us. So what do they do in their opposition? Most of the time they spend saying that the prosecutors themselves did not know. They had no actual knowledge. While they concede the unavoidable in their moving papers, which is that the Massachusetts State Police and the Canton Police Department both knew about the evidence and both withheld it.
All right, we can mark off Sallyport too.
Conveniently, they throw much of this on the back of Michael Proctor. It was sort of to be expected. He's already damaged goods, so why not?
Trooper Proctor!
Bring in a newly
mark that one
sergeant, off. Sergeant by the name of DG Petro, who's already retired, gone from the police force, and who interestingly retired.
Yeah, it's not that I can't tell the difference between the two attorneys because they don't look anything alike. It's just that I get their names mixed up. I, for some reason, want to call I want to call them different names. I don't know why. I don't know. But Dr. Russell, thank you for that. For the 20 says Dr. Russell is the GOAT. Jackson equals dark hair and beard, Unetti, Silver Fox. Yeah, I know who they are, but I can't, for some reason. The names of these attorneys just keep escaping me, and then I never know which one to call which. And I've watched them for what? I watched the whole last trial. You'd think I would know this by now. It's just a brain block. Sometimes I get a brain block for faces, and this has just happened.
Just 2 days after the Commonwealth's October 2024 disclosure revealing previously withheld Sallyport video.
I'm just going to ask, is he available, Mr. Brennan?
Not today, but he could be available.
I'm just curious, so he's still around?
He is,
Okay.
yes, and he's cooperative.
All right, Mr. Jackson, go ahead.
Our motion illustrates that, and by the way, I'll walk through the videos that we did get and when we received them. Our motion illustrates that dismissal in this case is required because of the cumulative impact of clear-cut discovery violations, clear-cut, inexcusable Brady violations. And from a legal standpoint, the conduct in this case is so egregious, it's so pervasive, and it's so deliberate that prejudice must be presumed. We don't have to prove prejudice, it should be presumed. To begin, I want to start the issue by talking about the condition of Miss Reed's passenger taillight. The condition of that SUV passenger taillight at the time it was brought into the Sallyport at Canton PD is of critical importance, and that may be one of the most important facts in this entire case. It's important because we know as a fact now that not a single piece of taillight was ever recovered at 34 Fairview until after that vehicle was in the possession of Michael Proctor and the Massachusetts State Police. That is the foundation on which this entire argument is built, and it is an undisputed fact, although it wasn't undisputed for years.
Oh, is anybody on Rumble?
Other material facts that are not in dispute. The Sallyport video has been...
Hey, is Rumble working today? By the way, I do have the locals chat open, meganfox.locals.com. Those of you who are members over there, there's a live chat going, so you can send memes and stuff, which is a lot of fun. But my question is Rumble's working. Yay! All right, I figured it out on Streamlabs how to get Rumble working. It's not as easy as StreamYard, but I've got to get this down by March. What did I say? March 24th when StreamYard is going to charge me $780 for their shitty service. So I have to get used to using Streamlabs, and I appreciate your patience as I work through this. So it looks like today Rumble is working. Hello over there in the Rumble ghetto. If you are not a member of my Rumble channel, you should definitely do that. Go find Megan Fox Investigates on Rumble, because when I can't do things on YouTube because of censorship or whatever, then we get to do it over there because there is no censorship. So I figured it out today. Yay! Yay me. Yay me. I look washed out, though. I don't know what's with the light today. I think maybe too much natural light coming in from the bathroom window. I should shut that door. Maybe that would help. I don't know. I do have to figure out the lighting. Here we go.
In the possession and custody and control of the Commonwealth since January 29th, 2022. That is a fact. It's also a fact that none of it, not one bit of it, was ever disclosed to the defense until April 4th, 2024. On April 4th, and I want to walk through what videos we did get and when. On April 4th, we got 2 videos. One was the Sallyport interior front wall. That was the video that was missing 42 minutes, which was the 42 minutes where it would have shown the car being pulled into the Sallyport. And we also received a Canton Police Department driveway video with the SUV on a flatbed, which did not show the rear end of the car. On April 23rd, 2024, and by the way, April 4th, the court will recall, was just in the shadow of the beginning of the trial. On April 23rd, in the middle of the trial, we received another Sallyport interior back wall video. That was the video that is now sort of famously inverted. On October 10th, 2024, 2 days before Sergeant D.G. Petro retired, we received 4 videos. The Canton PD interior hallway, the Canton PD rear lot main side, the Canton PD rear lot cruiser side, and the Canton PD
you may check off
exterior Sallyport.
New info about video.
Exterior, because it becomes extremely important in just a moment. These are 4 videos, all of which show Brian Higgins in some way, shape, form, or fashion at the Canton Police Department on January 29th, 2022. Then on January 28th, 2025, the Canton Police Department main driveway side exterior Sallyport was given to us. That's a grainy and very wobbly video that nobody can sort of make heads or tails out of. You can see the general outline of a vehicle, but the condition or the quality is so bad that you can't tell what the condition of the taillight is, which is what we're interested in. And I bring this to the court's attention, or I highlight this, because this is the second exterior Sallyport video that we ever received. One on October 10th, one on January 28th, 2025. Then on Friday, this past Friday, something pretty remarkable happened. We just received a report from Sergeant Buchnick, dated February 28th, which is 5 days ago now. And he makes an important admission in that report for the very first time during all of this. He indicates that in May of 2024, during trial, he was, quote, provided with a thumb drive and the CD labeled with a Post-it note on my desk to review prior to testimony. He goes on to say, quote, at this time I reviewed the video and I reviewed video made available to me, which included video footage of the Canton PD exterior Sallyport. Exterior Sallyport. That means that the Massachusetts State Police not only had in their possession exterior Sallyport video, but they knew about it and were reviewing it during trial. But we didn't get any of it until, as I just said, October 10th, we got one.
Rumble, thanks for the rant over there. JC Chappie sent $5 for the Kick StreamYards fund. Chat, join Megan's Locals. Locals is a lot of fun. And actually, if Brad is available after this, we may do a Locals only Caleb Hammer stream. Those are always so fun. And we had one planned last week, but I was sick. I had a terrible headache, and so that did not happen. I will text him and see if he's available after this, because we'll go do a Locals only and maybe a YouTube members only Caleb Hammer stream. Those are so fun, which means I'll skip the gym. But oh well. Well, maybe I'll just go later.
January 28th of this year, we got the other. So that was withheld from us for the entirety of the first trial, and all the way until at least October 10th, possibly as late as January 2025. And they've now admitted that. But who else knew about this withheld video in May of 2024 during trial? On cross-examination...
So can I just ask, was this of better quality than anything
Bev
had, or
interrupts.
the same wobbly?
Same.
Defense.
Same. Wobbly, grainy, can't make heads or tails out of hardly any of it. No. The question is, who else knew about this? Did anybody else know about this being withheld from us in May of 2024 during trial? On cross-examination on June 6th, Trooper Buchnick admitted to reviewing video evidence with Mr. Lally in May of 2024 in prep for his testimony. Was that the video that they were reviewing together? Was it the exterior Sallyport video? We now know that Buchnick watched some sort of exterior Sallyport video. He admits it in this report that we just got 5 days ago. And we also know that he and Mr. Lally were reviewing video together before his testimony in May of 2024, because he admitted to that on cross-examination during trial. But I didn't have information about what he was reviewing, because we didn't have the videos. So either they reviewed together the inverted video that was then played, and knowingly presented false evidence to a jury and to this court, or they reviewed exterior Sallyport video and intentionally withheld it from us. This is binary. It could only happen one of two ways. Either it was the inverted video that they prepped on and then presented inverted video to the jury, which is a problem, or they reviewed external or exterior video and did not provide it to us intentionally. Either way, the withholding that evidence admitted to now by Trooper Buchnick was obviously egregious. It was obviously in error. It was obviously calculated. Another important material fact not in dispute. On April 10th, 2024, the DA certified disclosure of, quote, all evidence.
Sorry, can I just get back to that? What you were just
Bev interrupts again.
2023.
Yes.
How is that exculpatory?
Because the videos themselves, as the court will see through the presentation of my oral argument, that the fact that those videos all just happened to either be grainy, wobbly, missing 42 minutes, or from the wrong angle and flipped backward, all tend to show that the Commonwealth doesn't want the condition of the taillight to be seen by anybody when it's pulled into the Sallyport. That is a reasonable inference. In other words, it's the cumulative effect of the bad videos that helps us. That's why it's exculpatory.
All right. And also, could you explain to me the prejudice?
I will get to the prejudice as I move through
now
my
or no?
All right. The chat wants to know if that counts as bitch Bev, but no, it doesn't. It gets worse. It gets a lot worse. This is just normal. This is normal Bev. This is just Bev hating the defense. So I think that we definitely have Bev interrupts defense. We haven't got a Bev sigh yet though, but it's coming. We also haven't seen her hair yet. And then when we do, it's definitely bad. You can check that off. And doctored video, not yet. There's a moment where you're going to see some doctored video, like some actual doctored video. And the weird part is the prosecution is going to put it up. So let's wait on that one because it's there.
If you're going to do it later, that's fine.
I will do it later. I think the prejudice is cumulative. Obviously, we didn't have the information that we needed to be able to cross-examine the witnesses that we needed to be able to cross-examine at the time that it was provided. Okay. It just very obviously.
Oh my God, EMT, this is the best. This is the best compliment ever. EMT 2666 says, I used to be all for the state until watching all of y'all cover the trials. The one that turned me more against the state was Legal Vices and Megan. I will take that. I want to put that in my bio. Turning people against the state since 1976. That's me right here. Right here. Turning people against the state. Never trust the state. Never trust the state. Are you kidding me? With their immunity and all their excuses, you can't trust the state. These people tell lies. They will put you in prison forever. And wait till you see what they're trying to do to Aiden Carney. When we get to the Turtleboy portion of this, you are going to flip out. I think maybe I should change my background today to match me. I'm pink today. Should we have a pink background? Here we go. Yeah, that's better. Wait. Nope. There we go. I feel like that matches my outfit today. All right. How do I get back to the chat? Streamlabs is a little difficult for me to figure out on the fly. Here we go.
There were certain videos that were clear from some cameras on other days and other times, but these cameras that were late discovery that was provided to us just so happened to all go out. They all find their way to be defective in one way or another at the exact moment that we would need them.
Oh, Bev sigh. Bev sigh.
The DA filed its certification of giving us all evidence that they had in their possession, and that they had done a reasonable inquiry. Both of these, that certification was just flat not true. How could that be true? And we're still getting video evidence that is in their possession, custody, and control in October, in January. How could that possibly be true? It isn't true. And it's illuminating when you look closely at the Commonwealth's opposition to our motion. First and notably, the Commonwealth makes these broad statements couched as fact. They're bold pronouncements, and there's myriad excuses in their opposition paperwork. And it's backed up by next to nothing. Not a single exhibit at the time they filed their opposition. There's some exhibits that have been lately provided, including some exhibits just a few minutes ago that they're now adding to their exhibit list and to their opposition.
Elisha Tousley, thanks for the 2. Do we have to do 5 different size or the one? No, we have to have 5 different ones. So there's you can only mark off one side at a time. Trust me, there will be enough. So I have to mark that off actually. Bev Sci. Just be strategic about where you put them. So like here, I'm going to use this one up here because I've got close to a bingo on this row. So I'm going to put my Bev Sci here. But so just be strategic about the Bev size. That's all. That's what you got to do. Oh, God.
But in point of fact, at the time they filed their opposition, there was no factual support for any of its positions.
So are you pointing me to something specific, or are you just saying in general and you'll wrap it up?
In general, the
oh my God.
They had today.
That was a Bev bitch moment. So you're just saying in general and then you'll wrap it up. Like, what? I'm calling Bev bitch on that one. Good Lord.
Opposition was this joint affidavit that doesn't address any of the defense allegations at all. Contrast that with the defense motion, which was supported by nearly 20 fact exhibits. There may be a reason why they didn't support their positions with exhibits at the time. It's because the facts don't support the Commonwealth's position. These are indefensible and indisputable facts that I'm explaining to the court about the turning over of these Sallyport videos. Specifically turning to the Canton PD surveillance video. The opposition says, or reads, the Commonwealth provided the defense with a...
I just always like to read along. Where does it say it?
I don't have the page number.
Okay.
It's the point at which the Commonwealth indicates that they provided 90 photographs, crime scene photographs in support of the vehicle in the Sallyport. That is a distraction. What they don't mention in their moving papers is that the date of those photos were all February 1st, 2022. There are no photographs from January 29th, 2022, when the vehicle was brought into the Sallyport. The only thing we would have would be the videos, the surveillance videos, all of which are somehow, some way defective and which were held in their possession in some instances for nearly 3 years before it was turned over to us. So it's the condition of the car at the time that it was brought into the Sallyport on January 29th at around 5:30 p.m. that matters. That's the only time that it matters.
All right, folks, there are 457 of you here, and I'm so glad that you are here. Let people know that we're streaming. Share the stream. And also, please hit that like button. We're only at 222 likes, and I think you can do better than that. I mean, unless your thumbs are broken. But are your thumbs broken? I don't think so. Slap that like button like you would like to slap that sigh right out of Bev's mouth. I mean, really, hit it hard. Get all your aggression out on that like button. And if you don't like it, you can hit the thumbs down too. It helps the algorithm either way. So, hit the like and subscribe. Where are we at now in subscribers? Let's see. Where am I at? I can't tell from my studio. Anyway, we're a bit over 52,000, I think. And I'm looking at, my goal for the year is to hit 75,000. So if you haven't subscribed to this channel, definitely do it. I think you will be pleasantly surprised. It's weird here, but you'll like it. And if you don't like it, you'll rage quit and you'll send me a hilarious email that I can share and we'll all laugh at it. In Boston, you may have broken thumbs. Well, that's because of the thug police force, right? Oh, God. Make sure you hit that like button, though. We're getting it up there. It's up to 306. Don't make me pull this chat over. Just hit the like button now. Save yourself the trouble.
The other evidence referenced by the Commonwealth about a 5 a.m. ring video and Canton police cruiser at 8 a.m. and the independent observations of Dighton police officer Sergeant Barrows, they all corroborate the defendant's contention that the taillight was cracked and not shattered.
Slug says, thanks for the 2. Will do, Grandma. Disliking now. Damn it, now you're making me take my blood pressure. I just know it. See, you're pissing me off, and now I'm going to have to take my blood pressure, Slug. This is all your fault. All your fault. This is what life is like in your 40s. I'm only going to be able to say I'm in my 40s until next April. Not this April, next April. All right, here we go. I'm not supposed to talk. Deep breathing. It's not going to be good. I can feel it already.
At the time it was brought in to the Sallyport. And we're still talking about the condition of the taillight, obviously, when it was brought into the Sallyport. The Commonwealth next mentions that, Lieutenant O'Hara from the CERT team arrives at 32 Fairview Road at 4:56 p.m. They then go on to mention that he was preceded by another trooper at 4:54 p.m. and that the car got to the Sallyport at 5:30, suggesting, obviously, that the search began and
oh,
taillight
Jesus.
pieces were found.
I think I have to go to the hospital. Wait. Can you see that? 152 over 105. Damn it, Slug. You know, you need to behave. That is so bad. Ah, that's like the highest reading of the day. 152. I have to write that down. What did I? 152 over 105. Shit, it's not good. No, the band's not that. What you're telling me I need to tighten the band? But it already hurts. It already hurts. All right, fine. How tight does it have to be? I don't want it to break my capillaries or whatever. All right, we'll do it one more time.
Found before the car ever arrived. That would be interesting if it were true, but it's not true. It's a distortion of the truth. It doesn't matter when the CERT team actually arrived and drove up there and sat in their warm cars and waited for other team members. The last team member to arrive didn't arrive until 5:41, 11 minutes, long after the car had already been secured in the Sallyport, long after Trooper Michael Proctor had access to that passenger taillight. The first taillight piece was not seen or found or recovered until 5:45 p.m. after the vehicle's arrival at Canton PD. That was seen. We can see who's got access to the vehicle and who makes access to the vehicle in that inverted.
It's not much better. 150 over 96. It's still too high. Definitely too high. Damn it.
Video. Once we turn it back around, it's very obvious. It's Michael Proctor milling about at the passenger taillight. These are important details to get right. The timing matters. The opposition claims that the defense theory is quote unquote evolving. They write that the defense, quote, struggles to establish how the condition of the defendant's broken taillight in Canton, in the Canton PD Sallyport, is in fact exculpatory. How is that exculpatory? The condition of the taillight, that it was cracked and not shattered as it moved into the Sallyport. How do we struggle to describe that as exculpatory? Of course it's exculpatory. Of course having those videos withheld from us is prejudicial. There is no struggle. It's on the video, it's on the ring video that establishes that the right rear Lexus hit the back of the Chevy Traverse, cracking its taillight. The Commonwealth, pretty desperate to ignore that inconvenient fact or that inconvenient piece of video evidence, literally previously said in open court that the Lexus only got close to the Traverse, only to be completely impeached when everybody in the courtroom at trial saw that 5,000-pound Traverse jostle, its rear wheel jostle, under the impact of the SUV right at the right rear or the passenger side taillight. Now the Commonwealth, with no factual support, no factual underpinnings whatsoever, says, okay, hang on a second. It did hit it, but it didn't crack the taillight. So whose theory is evolving? Ours or the Commonwealth's? The defense has never wavered. We knew that Michael Proctor, from the very beginning of this case, had been lying about the time he first took possession of that SUV. He claimed that it was at 5:30. The court will recall this. We had litigation concerning this. He wrote it in at least 9 reports that we were able to count. 9 reports or affidavits. Those affidavits sworn under oath. And
welcome to the Fox Den.
That time for nearly 2 years.
Thanks for joining.
He goes so far as to argue to this court that the defense got it wrong, that we were wrong because we failed to calculate for daylight savings time. So the Commonwealth battled us, and this is something I think the court has to really weigh and balance, the following conduct. The Commonwealth battled us for nearly 2 years on the singular issue of the time that the SUV got to the Sallyport. They finally took their medicine at some point and had to admit to the false time and chalked it up to a Scrivener's error in 9 separate documents, memorialized 9 separate times, some of them under oath.
9 times
and
an error.
While,
sure.
While they were battling us on the time that it got there. No, the defense is all wet. They're wrong. They just didn't account for daylight savings time. Oh, no, this was just a little mistake. It's not a big deal. It was a Scrivener's error. And the entire time they're making both of these claims, they had video in their possession that established unequivocally that that car was in Michael Proctor's possession at 5:30 and pulled into the Sallyport at 5:30. They knew the time. They knew that he had retrieved it at 4:12 in the afternoon and not gotten it to the Sallyport until 5:30. So the Commonwealth was well aware in 2022, the Commonwealth and their agents were well aware in 2022 that the SUV got to the Sallyport, and that was the centerpiece of the defense case. They knew that the videos would directly impeach the lead investigator on this case, and they say that we struggle to explain the exculpatory nature of this evidence. It's not our struggle to explain it, it's their struggle to acknowledge it. Of course that's exculpatory. It directly and unequivocally impeaches their lead investigator on one of the most important issues in the entire case.
Yeah, and if they're so sure it's not exculpatory, then why don't they want to see it? How come they're not moving heaven and earth to make sure that they get this video they claim shows nothing? In fact, maybe now is a good time to take a break for a second from this because we're on the topic and get over to Aidan Carney's most recent article about this issue. It's not very long, but it does point out some really interesting things. So let me share this screen. Let's read this for a minute because I found this to be a good catch-up. All right, here we go. How do I get this on this? There we go. All right, let me make me smaller so this can be bigger. He calls it Canton Cover-Up Part 484. That's how many articles he's written about this. Hank Brennan's opposition to motion to dismiss blames everything on Adam Lawley and Canton police, debunked by screenshot of videos from first trial. Yesterday, he calls him Spanky. We'll just call him Brennan. Yesterday, Brennan and the Commonwealth filed their opposition to Karen Reed's motion to dismiss, and it's as pathetic as you imagined it would be. He claims that the defense never filed a motion to preserve surveillance video from the Canton Police Department. We know that's not true. So they didn't violate Rule 14 because surveillance video wasn't included on the defense's list. And here it is in his motion. It says, despite claims to the contrary, the defense never filed a motion to preserve prior to November 2024 surveillance video from the Canton Police Station. But they clearly did. And here's an excerpt from their request. It says, all turret tapes from any local police department and the Massachusetts State Police regarding this matter, from the first time the police were contacted to the arrest of the defendant. How is that not clear? They absolutely asked for it. And it really pisses me off that they can just stand there and lie and say that it wasn't requested. Brennan's reasoning, the defense asked for all physical evidence from the crime scene in the Canton Police Department is not the alleged crime scene. Yeah, seriously, that's the argument he makes. The defense claims their February 2 request for all physical evidence, including anything present on or near the decedent at the time his body was discovered, anything found at the alleged crime scene, was sufficient notice to the Commonwealth to preserve footage from the Canton Police Department's Sallyport, where the defendant's vehicle was stored for approximately 2 days. Exhibit A, the Canton Police Department is not the alleged crime scene. Well, it might be. It might be. The Commonwealth could not reasonably have anticipated the defense's ever-involving third-party culprit claims, nor to this day made the Canton Police Department video pertinent to their amorphous and fluid claims. But look up here. All turret tapes from any local police department. How is that not clear? Yet Nicholas Guarino referred to the Canton Police Department as the crime scene in a February 4th, 2022 report when he said that Michael Proctor picked up John O'Keefe's phone while on scene. Michael Morrissey previously stated that Proctor never went to 34 Fairview Road and that the scene referred to in this report was CPD. To Detective, and here's February 4th, 2022. Detective Lieutenant Brian Tully, to him, this is an email from Nicholas Guarino, cell phone extraction and forensic analysis of a cell phone belonging to John O'Keefe. On Saturday, January 29, Trooper Michael Proctor and Sergeant Yuri Buchanek of the Norfolk District Attorney's Office responded to an unattended death of John O'Keefe. at 34 Fairview Road in Canton. Through this investigation, it was found that O'Keefe was a victim of a motor vehicle homicide. While on scene, Trooper Proctor secured O'Keefe's cell phone and brought it to the Norfolk DA's office for forensic analysis. The defense alleges that a new video given to them on January 28th from outside the CPD Sallyport garage is the correct angle to show the condition of Karen Reed's right rear tail light, but that the video is too blurry for them to see who was going into the garage or what the tail light looked like. According to Brennan, it's no biggie because the poor quality meant that neither side could benefit from the tape, and there was another video angle showing the car enter the garage. The defendant cannot show irredeemable harm to her right to a fair trial as it relates to the Canton Police Department surveillance video. While the January 28, 2025 production was untimely, they're admitting it was untimely, the poor quality of the video makes it difficult for either party to benefit from. Furthermore, the video depicts the same event that was contained on the surveillance videos produced in April, simply just from a different camera angle. Further, while the Commonwealth would argue that the videos from the Canton Police Station Sallyport are inculpatory, the defendant benefited during the first trial by suggesting without any substantive evidence that the poor quality of video and or gaps in time due to an improperly functioning camera system were caused by an improper police investigation and systemic police misconduct. Question: why is Karen Reed the only one who seems to want to see these videos? If the Commonwealth is so convinced that she is guilty, shouldn't they be the ones trying to get these videos? Shouldn't Karen Reed be attempting to suppress the videos? Either way, the problem with the different camera angle from the other video is that the right rear tail light can't be seen, which Brennan is well aware of. Brennan's defense seems to be they never gave it to us. After inquiry, it was learned that an investigator obtained this video from the Canton Police Department in 2022, and it was placed in a physical case file and never provided to the prosecutor, a likely story, or multimedia assistant for download. Had the prosecutor known about this video, it would have been produced, as every other video known to the prosecutor was. But it doesn't matter. This is on the Commonwealth. It is their job to hound CPD until they get the videos, not blame them for not doing their job. Regardless, Karen Reed had a right to all of the videos and it wasn't provided to them, which is a Brady violation and warrants dismissal of all charges. Yes, it does. During the trial, the defense received two videos, the inverted video and the dark video you couldn't see. Brennan claims that a video technician for the Commonwealth clarified the video footage, and on October 10, 2024, the defense received clarified videos so they could actually see what was happening. After the trial, and this is a excerpt again from a filing, after the trial, a certified forensic video technician employed by Norfolk District Attorney's Office reviewed the surveillance footage that had been previously produced to the defense. Recognizing that the video was extremely dark with minimal visible detail, the video technician clarified the video footage, so they doctored it. On October 10th, the Commonwealth produced to the defense clarified videos. Reports detailing the forensic clarification process, associated hash values, and extracted still images from the Canton Police Sallyport. Furthermore, the video technician clarified video images from Canton. There is no excuse for not providing this during the first trial. Yup, that is absolutely correct. No excuse. Brennan claims that the non-inverted version of the CPD garage video was played by the Commonwealth at trial, but that didn't happen until the next day after it was all over the news that they played the inverted video and didn't alert the jury. Brennan claims that the video shows Trooper Proctor never touched the car and was standing feet away from it. The Commonwealth played the entirety of the corrected yet altered video, which reveals that Trooper Proctor is standing feet away from the defendant's vehicle and never touched the rear taillight. Further omitted from the defendant's filing is the fact that Trooper Proctor's DNA was not on the right rear taillight. The video does not show that at all. You can only see his head, and it's unclear how long or far away he was from the vehicle. He looks to be right next to it, but his body and hands are hidden. That is correct. On April 17th, a day into jury selection, Chief Rafferty once again decided it would be a good time to send over some more videos she forgot that she had laying around. It's not Brennan's fault, though, because he didn't know of its existence. Okay, so he's in his motion, the prosecutor had not previously received this video or knew of its existence. Helena Rafferty and Adam Lally both need to be called as witnesses for this trial, and Lally should be recused as a prosecutor. These people shouldn't be able to blame each other at Karen Reed's expense. Just this evidence alone, that these videos were withheld, doctored, not given over, this is enough. Dismiss this case. It's disgusting. Commonwealth is saying that they didn't hand over Canton Police Sallyport video because they didn't know it existed, because investigating officers didn't tell them about it. The first videos they handed over were on April 4th, 2024, weeks after Karen Reed filed her motion to dismiss. Thus, she could not include this devastating evidence of Rule 14 violations in the MTD. So nevertheless, the trial prosecutor was not aware of the existence of surveillance video in the Canton Police Department's Sallyport until the federal grand jury transcript of Massachusetts State Trooper Michael Proctor. Prior to that, the prosecutor had not been alerted to its existence by investigating officers. Thank you, Dr. Russell, for the super chat. Call him Prosecutor Breenan. He did it in his motions. He calls himself Breenan, or did he misspell his own name? That's funny. Promptly on April 4th, 2024, the Commonwealth provided the defendant with 9 surveillance videos in his possession consisting of all this stuff. Notably, the quality of the video is poor in certain portions. However, that is the condition it was recorded in, and the condition in which it was received by the prosecutor. So convenient that the condition of the videos is so poor. The Sallyport camera was replaced due to its defective condition, and during the first trial, the Commonwealth called the technology director for the town of Canton to testify about surveillance video systems throughout the town. And sure, the quality of the video is poor, but they've fixed the problem since then, so the next person framed for murder will have a better chance to prove their innocence. As has been pointed out by online sleuths, the Commonwealth appears to be lying about not receiving these videos before April 4th. During the trial, the Commonwealth showed a folder of all their Sallyport videos, and several are dated June 2023. Oh boy, that's a problem. This wasn't an oversight. It was malicious. Adam Lally needs to explain himself. As for the jury tampering claims in the motion to dismiss, the Commonwealth confirmed that these were about John Fanning's overseeing of the jury, resulting in a juror who was making faces that she believed Karen Reed was not guilty, being dismissed on the final day of trial. This juror was reported to have been speaking about the trial 6 weeks prior at a bar. And again, this argument is going nowhere. At no time did Lieutenant Fanning enter the Norfolk Superior Courthouse during the defendant's trial. Moreover, he never saw, let alone spoke to any member of the jury. Really, if he never saw one, how did he overhear her at a bar? Flux sighting! You didn't get a notification? I'm so sorry. I should have, when we were texting earlier, I should have told you. Paranoia07, thanks for the 5. I don't know how you and Umbrella Guy are not all over this case. Well, there's only a few, we can only do so much at once, and I'm trying to keep up with it. The Hales case is pretty all-consuming. All right, so we can skip over the jury stuff. The jury stuff, I don't think that's going anywhere. I really don't. And we'll go back over now to, I want to talk about the video. Because frankly, I don't care about the jury stuff. The video, the withholding of the Sallyport video is so egregious that this case should have been dismissed immediately upon knowledge of this.
And that's only one aspect of the withheld videos that also is exculpatory. The other is the point at which it would show the condition of the taillight. In other words, when it's being pulled in to the Sallyport, would it show the condition of the taillight before Trooper Proctor had access to it in the Sallyport? That's what we've been seeking. The Commonwealth is well known from the beginning of this case that the defense has demanded all physical evidence be preserved. That is, this is not a game of Wordle. This is not something that's supposed to be parsed. All physical evidence be preserved. That's pretty straightforward. The Commonwealth shouldn't be in the business of withholding exculpatory evidence by playing some sort of a gotcha game with definitions of words. They knew what we meant. We don't actually know what the Commonwealth has, so we have to be as broad as we possibly can when asking for evidence to be preserved. So all physical evidence clearly includes the entirety of all the Sallyport videos. The Commonwealth parsed his words by saying, well, we never asked for the Commonwealth to preserve the CPD footage from the Sallyport because the Canton PD is not the crime scene. You asked for crime scene footage, and Canton PD is not the crime scene. Well, first, I think that's a disingenuous argument that plays right into that sort of gotcha that we've discussed. I think the Commonwealth is better than that. That's not what we should be doing in a trial for murder. And second, let's not forget that District Attorney Morrissey actually defended publicly Michael Proctor by explaining that when Michael Proctor said he responded to the crime scene, and of course we knew he didn't respond to 34 Fairview, D.A. Morrissey said, oh, he was talking about Canton PD, which is the crime scene. So they can't have it both ways. They write on page 4 of their opposition, quote, the trial prosecutor was not aware of the existence of surveillance video in the Canton Police Department's Sallyport until receiving the federal grand jury transcript of Massachusetts State Trooper Michael Proctor, end quote. So they've taken the position, look, we personally did not know anything about that Sallyport video existing until we received the federal grand jury paperwork showing that Michael Proctor testified to it. First, the Commonwealth has to know that that is not the state of the law in Massachusetts. Massachusetts State Police and Canton Police Department are both arms of the prosecution actively involved in the investigation of this case. Not one, but two separate agencies not only knew of the existence of the footage, but the lead investigator actually admitted to a federal grand jury that he pulled the footage at the start of the case. He pulled it all. And then he said he reviewed it all because that's what the case agent does. The Commonwealth cannot absolve themselves of the egregious and very obviously intentional discovery violations by Michael Proctor, by the Massachusetts State Police, by the Canton Police Department, by saying, I personally didn't know about it. The cases are legion on that issue. Commonwealth versus Sleeper, 2002 case found at 435 Mass 581, and this is Hornbook law. Quote, a prosecutor's duty to disclose exculpatory information or exculpatory evidence extends to evidence in the possession of the police who participated in that investigation. And then Massachusetts Rule of Criminal Procedure 14A1A, the prosecutor shall disclose information covered by mandatory discovery, provided it is in the possession, custody, or control of the prosecutor. Persons under the prosecutor's direction or control, or persons who have participated in investigating or evaluating the case and either regularly report to the prosecutor's office or have done so in this case. Michael Proctor worked out of the Norfolk DA's office, physical plant. There is no question that Michael Proctor and both agencies intentionally withheld that evidence. Let's talk about Michael Proctor's testimony before that grand jury. He was asked the following question. Are you aware whether there are any cameras in the garage or Sallyport where Karen Reed's SUV was parked? Answer, yes. Question, have you reviewed the footage of that garage? Answer, I saw one very grainy video and then another of Sergeant Buchnick and I arriving in the main entrance around 5:30 following the vehicle. Question, when did you watch the video from the Sallyport? Answer, I haven't reviewed it, sir, in quite some time.
So do you have those page numbers for me?
I can get them for you, Your Honor.
Okay.
I didn't cite them in my notes.
Yeah, if Ms. Little can get them for you before you finish, that would be helpful for my review.
I haven't reviewed it, sir, in quite some time, so I can't recall what's on there. Question, why did you review video of the Sallyport? Answer, we review every video we pull. We pull a lot of video. It's on the case officer to watch it. By his own admission, Your Honor, Michael Proctor recognized himself in a video along with Sergeant Buchnick. That was likely the video that ended up being inverted by where Michael Proctor was by the passenger side taillight.
And I just need to remind you that Trooper Proctor was the trooper who referred to Karen Reed as a C word, as a see you next Tuesday in text messages. He made fun of her medical condition. He made disgusting jokes about looking for nudes on her phone. This is a man who this case should have been thrown out based on his text messages about the defendant. The bias in the investigation towards Karen Reed was off the charts. And this is the guy we find out who had the videos. Oh, we get some shocking stuff. I didn't know. Maybe you guys knew this. I had no idea he was the one holding on to the videos. Wait till we get to that.
And that was before any taillight material was ever recovered at 34 Fairview. That is highly inculpatory of Michael Proctor. It is highly exculpatory of Karen Reed. Another point of fact, by his statement, Michael Proctor admitted that, quote, we pulled, end quote, the video. That video is on a 30-day overwrite. The Michael Proctor testimony in front of the federal grand jury is at page 79, lines 1 through 13.
Thank you. Thank you, Ms. Little.
Exhibit C, is it Charlie?
Okay.
All right, sorry, Jim. You're right.
The video's
He's a pig.
Overwrite, Your Honor. We all now
Proctor
know that.
is
We
a
didn't know that
pig.
before just a few weeks ago. I don't expect that the Commonwealth knew that either. This is new to everybody, right? But you have to have pulled the video within the first 30 days to even be able to review it. We've been getting these videos in dribs and drabs for not months, but for years. Actually, it's been months. Hasn't been years. He further admitted that it shows the SUV arriving in the Sallyport at 5:30, which means he wrote those reports and signed those affidavits, the 9 that I was talking about earlier, with full knowledge that there existed a video that he had and had reviewed that proved he was lying. It doesn't get any more exculpatory than that. And that was the video, that was the very video that was withheld from us, from the defense, for 2.5 years until the middle of trial. The Commonwealth says the, quote, trial prosecutor, end quote, was not aware. It's becoming a relatively common refrain in the opposition. That's neither a defense nor a justification for blatant and egregious discovery violations by the Commonwealth and its agents. The fact that the trial prosecutor, whoever that is,
Trooper Paul's pirouette. The pig DNA found on John's clothes proves Proctor touched them. Hey, we are climbing. We're at 598 now. Those of you who are here, make sure you hit that like button. Hit the like and subscribe. I appreciate you being here. And share the stream. Let people know we're live and going over this. This is very interesting information. And we are going to get to Turtleboy's hearing as well in the second hour. It's going to be good. Turtleboy's hearing was something else. I care about that case a lot too. It has a lot of implications for free speech. So we're going to go over that. Make sure you slap that like button like you want to slap Bev or Trooper Proctor for that matter. The pig DNA. That is so funny. I love it. Love it.
it's an interesting use of a name, of a pronoun. I don't know who the trial prosecutor is, but apparently the trial prosecutor, according to the Commonwealth, didn't know anything about this. But that's not a defense. Who is the trial prosecutor? Is it Adam Lally? Is it Laura McLaughlin? Is it both of them? And why are they only referring to one trial prosecutor when there were clearly 2 in the courtroom? They make the statement with no factual support for that anywhere. Again, the only affidavit that was supplied was a type of affidavit I've never seen before, where it's signed under oath by 3 different people. So which sentence goes with which person under oath? The single declaration is odd, to say the least, but it certainly doesn't define who's responsible for what statement in that declaration. We certainly know that it was not Hank Brennan. He was not involved in the first trial, so it can't be him. The Commonwealth writes, quote, the prosecutor had not been alerted to its existence by investigating officers, end quote, but claimed that on April 4th, they promptly presented the defendant with 9 surveillance videos in its possession. The Commonwealth received the federal materials.
Were those all from the Canton Police Station?
I'm sorry?
Were those all from the Canton Police Station, those 9 videos?
My understanding is those were from the Canton surveillance. They're talking about the Canton. I didn't go back and audit which 9 they're talking about because I thought we only received 8, but I believe they're all from the Canton.
Ms. Little, were they all from the Canton Police Department?
Yes, Your Honor.
Okay.
The prosecutor had not been alerted to its existence by investigating officers, but on April 4th, they promptly presented it to the defense. The Commonwealth actually received the materials that highlighted the fact that these existed in February of 2024, probably around February 21st, 2024, because that's when both sides got all the federal materials. That is not prompt. We presume that Mr. Lally has daily communications or had daily communications with Michael Proctor as the investigator, the lead investigator on the biggest case that the Commonwealth, this office of the Commonwealth has seen in a long time, and it took 2 months to produce an incomplete production of these videos. We didn't even get all of them at the time. The Commonwealth writes, quote, the quality of the video is poor in certain portions. However, this is the condition it was recorded in. Says who? That's a fact question, one that needs to be answered. And it's an important question. Who says that the Commonwealth received these, or I'm sorry, who says that this is the condition that those videos were recorded in? We've got no facts to support that whatsoever. And then the Commonwealth goes on and says, and that was the condition in which it was received by the prosecutor. That's also a fact question that needs to be answered. And these questions could be answered with a proper evidentiary hearing. The Commonwealth's representations about Louis Jutras, the technology director for Canton, being subject to cross-examination about the Canton PD video surveillance system is also just not true. They indicate, well, we had access to Louis Jutras and could have cross-examined him on all of these issues. Louis Jutras was called for a very specific reason, the town library video. We had no way of knowing at that time that he had any connection whatsoever with the Canton police video system. We were not told that until well after trial. That was never disclosed to us, and I think Mr. Brennan used this phrase not long ago, that would have been nice to know of Mr. Louis Jutras. The first time Louis Jutras was ever disclosed as the person who installed the cameras at Canton PD was in a report dated October 10th, 2024. According to Colleen Crawford, and the court's heard her name as well, one of the Commonwealth's experts, Jutras indicated that he replaced and disposed of the camera capturing the inverted video at some unidentified point between January 29, 2022, when the inverted video was actually taken, and July of 2024, because it was quote-unquote defective. Interestingly, that's the only video that's clear. It's inverted, but at least it was clear, and that's the camera that, according to the Commonwealth, was replaced as defective. A week after filing its certificate of compliance, after the defense brought to the court's attention that 42 minutes was missing from the Sallyport video that we did receive, lo and behold, the Commonwealth produces a new video that also purports to show the passenger side taillight, except, as the court now knows, that's the one that was inverted.
Okay, this right here, if I'm the judge, I'm like, okay, case over, dismissed. Dismissed. You were missing 45 minutes. You pointed that out, and then all of a sudden they're turning over another video. Done. We're done here. I'm done here. Why does she keep putting up with this other than she wants Karen in jail? I mean, I don't understand this at all. This would not fly in any other. You know, Alec Baldwin got off for less. The prosecution screwed up in that case too, and they didn't turn over Brady stuff. And the judge was like, yeah, sorry, case dismissed with prejudice. You're done here. The only remedy for this, the only remedy is dismissal. That is the only punishment, and I would sanction the prosecution. I would sanction them because this is crazy. This is beyond belief that she's just sitting there like, ho hum. I noticed that she has no shock and horror about what happened here. She's not gravely, what was the word she used the other day? Grave concerns. She has no grave concerns that the prosecution withheld this video evidence and just keeps on handing it out a bit at a time.
In the moving papers, in its opposition papers, the prosecution says, well, the prosecution had not previously received this video or knew of its existence. This is now the third or fourth time the Commonwealth sort of runs to this argument. I didn't know. We did not know about its existence. No matter how many times they write it, however, it does not change the Commonwealth's responsibilities. It doesn't change the prejudice that the defense suffered. We should have had these videos at the very beginning.
So, Mr. Jackson, I'm just going to ask you how much longer, this is the luncheon recess, but how much longer are you going to be?
Probably.
Oh, God. All right. She breaks here. She's always thinking about lunch, too. All right. We're going to go directly to 308 because this is when we get into the very horrific facts about Trooper Proctor's Trooper Proctor and his little grubby paws. Or hooves, I guess, his grubby hooves all over the video evidence.
Michael Proctor never approached or had any access to or didn't manipulate in some way, shape, form, or fashion. This was the intimation by the Commonwealth, that passenger taillight. The Commonwealth has now conceded that that person was, in fact, Michael Proctor. It's notable that the Commonwealth went to great lengths to state that, quote, Trooper Proctor, and this is in their opposition, Trooper Proctor is standing feet away from the defendant's vehicle and never touched the right rear taillight, end quote. That's a statement made in their moving papers, specifically on a fact that is of great material importance to this case. The three prosecutors signed an oath and a declaration, and the court just called the defense out on signing a declaration or an oath. And the court's intimation, at least, in its initial comments to me was, you may have said something that you don't have a factual foundation for. I think I have done my best to disabuse the court of that we were drawing from reasonable inferences. I wonder if the Commonwealth is going to get the same treatment for saying that Trooper Proctor was standing feet away from the defendant's vehicle and never touched the right rear taillight. That's a very bold statement for the Commonwealth to make, and it's also completely untrue. It's not supported by a single fact. It's not supported by a fact or evidence before the court. The problem with this unsupported motion, because it's unsupported and the declaration is signed by 3 different individuals, you can just sort of say whatever you want in the motion. And I guess get away with it. The video speaks for itself, Your Honor. It shows Michael Proctor walk behind the car directly to the position of the passenger taillight. He positions himself right on the other side of the camera view, not feet away. And it certainly does not show, and there's no evidence before the court, that he, quote, never touched it. As a matter of fact, we would submit.
Does it show that he does touch it?
Well, of course it doesn't show he touches it, Your Honor. It's he's on the other side of the car.
You can't see.
That's not the point. The point is, a reasonable inference is he could have touched it. He was standing right there. Nobody forced him. Nobody was holding a gun to his head. He walked around the other side of the car.
She is such a bitch. Well, does it show that he does touch it? Oh my God, just shut up and let him give you his argument. She spends all of her time arguing with the defense, and it is so frustrating. She is the most biased judge I've ever seen besides Judge Grudge. I think she's worse than Judge Grudge because of her physical manifestations of hatred towards the defense. Her sighing, her eye rolling. Not even Judge Grudge did that. I mean, he at least tried to pretend like he was being fair. This woman doesn't. She is just, ugh.
And obviously, was standing there for a reason. By himself, in a corner, out of the view of a camera.
Out of the view of the
when
camera.
The Commonwealth plays the video, it switched, and the intimation to the triers of fact was he never approached the right rear taillight, that passenger taillight. And all of that
And
was
you cleared that up.
Right. But that is the galling part of this entire thing. The court has asked me a couple of times, and I'm going to get to it a little bit more in detail, what the prejudice is. If that's not prejudice, I don't know what is. It's literally propounding false information to a trier of fact.
You know what really bothers me is that it is just accepted that judges are pro-prosecution. This is just an accepted fact. Any lawyer you listen to, any lawyer that practices will tell you this. And you know, in my experience watching courts and watching trials and reporting on courts and trials, it is absolutely the case. But that is not how it is supposed to be in this country. The judge is actually supposed to be biased toward the defendant. The state is supposed to give the defendant the benefit of innocence, right? That's what our Constitution says. The Constitution says you have a right to innocence unless the state can prove you guilty. And the judge is supposed to be on the side of the innocent person unless the state can convince the judge that that person is guilty of something. And we never see that. We never see it. So very rarely do we see a judge who starts out behaving as if they are giving the presumption of innocence to the person at the defense table. And I'm tired of this. I'm tired of it because we're not supposed to accept that a judge is just going to be biased towards the prosecution, and that's just the way it is. We need to stop accepting this. I want to stop listening to lawyers say, well, judges are always prejudicial towards the state. That has to change. It has to change. Judges cannot be prejudicial towards the state. They can't be known to be someone who is on the state's side all the time. This has to stop. At the very least, we're asking for you to just be neutral. But really, you're supposed to be on the side of the defendant until or unless the state proves to you that that defendant did something. So the judge is supposed to be looking with a skeptical eye at everything that the state is saying to them. That's what they're supposed to be doing. You are supposed to assume that that man or woman over there at the defense table didn't do shit. And you, Mr. Prosecutor, need to convince me that they did. And it's outrageous. I sound like, don't say that. I don't sound like a liberal. I sound like a constitutionalist. Well, actually a liberal in the classical sense of the word. Yes. Thomas Jefferson was a liberal, a classical liberal. And so am I. And the idea that a judge that we have just now accepted, that American judges are pro-prosecution. Fuck that. This has to change. It has to change. Yeah, they must assume. Yeah, not only must they assume that the defendant is innocent, but that they've been wrongly accused and that the prosecution did something shitty. And they need to prove to you that they didn't, that they were above board. And if you find one shitty thing that the prosecution did, just one, that case ought to go goodbye. We don't put up with this. And if you did that, if you had judges who do that, if you had judges who threw cases out regularly because of prosecutorial misconduct, instead of giving them all this rope, all these second chances, we would actually have much better prosecutors. We would get better convictions, because they would know that they'd get better investigations. They would be on their cops. Don't you dare screw this up. They would be on the police to make sure that they did good investigations, that they weren't doing shitty things like using solo cups for blood evidence and leaf blowers. This is how your system gets corrupt, by the way, by just giving the benefit of the doubt to the prosecution and the state all the time, as if the state is always right. Fuck the state and fuck these judges. It's enough already. I'm tired of this. This case should have been thrown out last time.
That is not a small thing.
Oh no. I have no sound again. I know you guys can probably hear it, but there's something with Streamlabs where I have no sound. So now let me make sure I know where I was. 3:11:23. I'm going to have to refresh this.
Clear data.
Nope, I still have no sound. So now I have to shut it down and reopen it. That is so annoying. I do not like that Streamlabs does this. This is a problem that I have noticed. So let me pull that back up. Yeah, now I have it back. Okay. Wait till we get to Turtleboy's hearing. Oh my God, I'm going to lose it. I'm going to absolutely freaking lose it. It's so bad.
Right. But that is the galling part of this entire thing. The court has asked me a couple of times, and I'm going to get to it a little bit more in detail, what the prejudice is.
Julie O, thanks for the 5. We should strive to put the Innocence Project out of business. Absolutely. Absolutely. How terrible that we have to have such a thing. That an entire organization that needs to raise millions of dollars to get wrongfully convicted people's convictions overturned. Terrible. And you're absolutely correct. But thank God for them. They do good work. And I hope that some of them are working on Sally Smith's victims that she put in jail.
If that's not prejudice, I don't know what is. It's literally propounding false information to a trier of fact. That is not a small thing. Even after the trial was over, it was concluded, and the mistrial was declared, we're still getting videos that we can't get a straight answer about their source. Where did these videos come from in October? That surveillance feed is on a 30-day deletion loop. That's what we've been told. I said a few minutes ago this morning, I said the Commonwealth may not have known that it was on a 30-day loop. What I meant was actually the prosecutors sitting in this courtroom. The three, my brothers and sister, may not have known about that 30-day override. I don't know. I don't know what they knew or didn't know. I'm certainly not going to cast aspersions and put that on them. But someone from the Commonwealth darn sure knew that was on a 30-day loop or a 30-day override. So who's had those for all this time? How were they stored? Why wasn't that information revealed to our expert when we went all the way to Canton to try to download that DVR? Where's the original? Where are the copies? These are questions for which
who
we
had
need
them?
Some facts.
Who downloaded them?
And the fact that those have been withheld from us is exactly the kind of bad act and bad faith that demands that the court presume prejudice in the case. A few minutes ago, the court asked me before lunch, what is the prejudice? There's plenty of actual prejudice, but I'll get to that in just a second when I speak a little bit about the law at the end of my comments. We don't need to prove actual prejudice because the law presumes prejudice against Ms. Reed.
Yes.
Because of the bad conduct on behalf of the Commonwealth.
But they're acting like the defense has to prove it. And they don't.
The Commonwealth recites this now worn out sentence. The prosecutor was unaware of the existence of these videos.
That's
End
not an
quote.
excuse.
How many times are they going to try to excuse away a blatant discovery and or Brady violation with the sentence that the prosecutor was unaware? It just doesn't matter. And that brings us to the October 10 videos that we got in 2024. The Commonwealth claims that they received these videos on or about August 21st, 2024. They sort of vaguely claim that these videos were provided along with a letter, quote unquote, letter from Canton Police Chief, end quote. There's no report, there's no email, there's no communications, there's no text message, nothing other than this, quote, letter. And it actually wasn't a letter, it was more of an informal note written on a personal pad, a Canton PD pad by the chief. There's no chain of custody log authenticating the videos, no authentication documents whatsoever, no foundational documents, no indication of where the videos came from or how she came to possess them at the time. But she did write on that little pad, quote, that is how it records, LOL, no tampering, end quote.
Oh!
LOL, laugh out loud. So the chief of police is laughing in the face of serious Brady violations, in the face of serious evidentiary violations and
what was the
discovery
date?
violations.
10/10/24
Fire
you
her.
received that? Was that the date?
10/10/24. That's correct. By the way, the Commonwealth claimed in its opposition papers that, quote, the prosecutor requested that both Massachusetts State Police and Canton Police Department produce all relevant and material surveillance video, end quote. And that was sometime unidentified between April 17th, 2024 and April 24th, 2024. I laud them for that. Good. I'm glad they demanded finally, in the middle of trial, quote, all relevant and material surveillance video. So why didn't we get this from Canton PD until October 2024, well after trial? What was the delay? And why did we get another video in January of 2025? What was the delay? How could this be seen as anything other than intentional? We know now that Sergeant Buchanan, we know that Proctor, we know that Chief Rafferty, and now through another report, we know that this officer, DG and Petro, all had access to and knew about the videos. And then we have, on top of that, in the middle of trial, I think it was Mr. Lally, maybe Ms. McLaughlin, someone said, it's unclear from the opposition, that all relevant material surveillance video be turned over immediately, and it still wasn't done. That is an intentional withholding of evidence. And then we get these new reports. What's probably most troubling is what's in the reports that we got on Friday, this past Friday. Additional reports from the Commonwealth, in a report from Sergeant DG Petro, he reveals the following. He writes this report on the 27th, which was last Thursday, and then we got the report on the 28th. He says that in February of 2022, and I'm paraphrasing, in February of 2022, Proctor requested Sallyport video of SUV inside Sallyport. Apparently that was provided. I mean, we have to presume from his report when he says Proctor requested in February of 2022 Sallyport video of the SUV exterior footage that he downloaded it from somewhere and gave it to him. Assuming it was February of 2022, that would have been before the overwrite, I presume. Because I think the math in my head is it's 28 days in February. If it's in February at all, it's within the 30 days from January 29th. So it has to have been. Then he writes that in June of 2023, Proctor requested Sallyport video again of the SUV exterior footage. Quote, this is from his report, I believe this may also have been the approximate time that I downloaded video recordings that covered the entire time frame that the suspect's vehicle was held at the Canton police station.
Oh boy.
He goes on to say, quote, due to the large size of the files at that time, I had to break it down into 6-hour blocks for ease of exporting.
Where are those
videos? This is
videos?
the first we're hearing of any of this. Last Thursday.
6-hour blocks? Where are they?
How is that? Sure. Ms. Lou just handed me a clean copy of the DG and Petro
so
report. I would like to have
crazy.
this marked and appended to our motion to dismiss if it's okay.
Sure. Did I get that attached to your motion to change the scheduling?
Yes. You probably did.
So I've seen it.
Okay. May I approach Representative?
Hold on. What, Ms. Little?
We'd still like to make it part of the record if that's all right, Your Honor.
Sure, I just wanted to know whether I needed a copy because I have a copy. I've seen it.
May I approach?
Yes.
Okay, thank you.
So are we marking it? So we need it if we're marking it.
Oh, I'm sorry. My mistake.
Exhibit 1 so marked? Okay. Go ahead, Mr. Jackson.
Thank you, Your Honor. The question is, how in June of 2023, now I'm going to go a little bit slow here just because it's linear. The argument is linear. In June of 2023, according to DG Petro, he downloaded every single bit of video of that car while in the Sallyport or while at Canton PD in Sallyport. How is that possible? How could that be? As of February 28th or maybe March 1st, those videos are gone. So how could he have access to the whole thing? It's because someone at the Commonwealth downloaded the whole thing. They saved it. Or the only other explanation is that DVR was not at the time on a 30-day override. It's the only two explanations. Again, this is binary. So in April of 2024, as the court knows, we got additional video, and that's the inverted video. In the spring of 2024, while trial was being held, DG Petro, quote, it says, quote, I downloaded some video recordings that you and I believed may be needed to refute claims being made by the defense. The you and I is him to Chief Rafferty. That's who this report is to. And it includes...
So they knew.
...of Higgins.
So they knew it was exculpatory, that we may need in order to refute claims. They knew it. This is so nuts.
So now we find out, for the first time, that Chief Rafferty and this sergeant had been talking and strategizing about how to defeat some defense arguments, presumably, by use of videos that had never been turned over. And the Commonwealth uses a phrase in its moving papers, I believe in this motion, about ambush. That is the definition of an ambush. So DG Petro admits that he, Rafferty, and the Canton Police Department had Sallyport video that was material to the case. Remember, his quote was that you and I believed may be needed to refute claims made by the defense. They were strategizing about how to defeat certain of our arguments, and they didn't turn it over. Specifically, he downloaded video and presumably gave it to Chief Rafferty. But then the interesting thing is, Chief Rafferty held on to it. She never turned it over. Probably because they didn't help the prosecution. They showed Higgins engaged in conduct that is, at the very least, highly suspicious and clearly exculpatory because it impeaches his other testimony. It shows him on the phone. And he testified that he didn't make calls in the middle of the night. There's no question that with this example, that is an intentional withholding of evidence. That is the legal definition of bad faith, and it's unconscionable to do that. Now put in context what we eventually did receive during the trial and then after. We received the inverted video that was falsely presented as the right passenger side of the vehicle, or the passenger rear side of the vehicle. Number two, we received several videos of Brian Higgins at Canton Police Department, clearly using his phone at approximately 1:35 or so a.m. And we received exterior footage that would ordinarily show the condition of the passenger taillight, which all happens to be corrupted, like every other video of the rear passenger side of that SUV. This is stunning. It's not like the Canton Police Department and the Massachusetts State Police were sort of blissfully incompetent or blissfully ignorant and unaware of the existence of these exculpatory videos. It's quite the opposite. Multiple officers, Proctor, Rafferty, Buchnick, O'Rourke, DG and Petro, these individuals, we believe, O'Rourke may not have known, but we know that the others did, and have now basically admitted it or been caught trying to hide it. They were all variously actively engaged with these videos. They were searched for, they were discussed, they downloaded them, they saved them, they copied them, they labeled them, they transported them, they reviewed them, and they strategized about them. These videos were top of mind for all of these folks. We know there were hours and hours and hours of footage that was so large it had to be broken down into 6-hour blocks. All of that was pulled. And none of this footage was disclosed to the defense before April of 2024. And most of the files that have been turned over so far have been turned over after the trial was over. We have no idea this footage existed, and to this day, it continues to be The bulk of it continues to be withheld from the defense. And then we move to Sergeant Buchanan's actual report. As I indicated, he wrote a report last Friday as well, dated the 28th. Quote, in furtherance of the John O'Keefe Canton homicide investigation, sometime in early spring of 2022, I was made aware that a request had been made by Trooper Proctor and then fulfilled by Canton PD for surveillance video as it related to the arrival and storage of the Lexus SUV belonging to Karen Reed. This was the spring of 2022, he knew. At Trooper Proctor's request, I proceeded to Canton Police and picked up the digital media storage containing said video and transported it to the Canton Norfolk District Attorney's Office and turned it over to Trooper Proctor. I did not review this video at this time.
What date did he do that? The same date?
He says at this time, but it's sometime early spring of 2022. That's the best he can do in his report. Paragraph 2. In July of 2023, so this is a little more defined, I was once again made aware by Trooper Proctor that a request had been made to Canton PD for additional video and that it was ready to be picked up. Since the Canton Police Department is conveniently located on my route of travel to work, I stopped by and picked up the CD from the front desk of the police department, which was labeled Trooper Buchanan with a yellow Post-it note. I further added Canton PD 12922 and then the case number, which is, or their case number, 2022-112-33, to note to more accurately identify the item and transported it to our office, subsequently turning it over to Trooper Proctor. So there's a second CD.
Proctor!
Now in July of 2023. I did not review that video at that time.
Unbelievable that this guy was holding these videos the whole time.
See the attached copy of the post-it. Final paragraph. In my preparation for trial.
All right, there are 726 of you here right now. Thank you so much for being here. And please make sure you hit that like button and subscribe. And if you have a couple bucks left over, don't spend it at Starbucks. Send it here. If you like this type of coverage and you want to see it continue, support the show. You can do so through Super Chats, Rumble Rants, Cash App, Venmo, which is running across the bottom of the screen. And let's see, I'm checking Rumble to make sure I didn't miss anything over there. So please do spend your Starbucks money here. Now, don't send me your ramen money. I don't want your last money for your food budget. Don't do that. Only send it if you can afford it. I appreciate it. It helps me to not have to turn on commercials, which is not something I hate doing that during live streams, because, you know, it interrupts the whole thing. I like to turn it on after the live stream is done. How are we doing on bingo? Let's go check out our bitchy Bev bingo. So far, I've got Trooper Proctor, Sallyport, Bev interrupts defense, Bev sigh, free space, police sirens, bitch Bev, and new info about video. Have we missed any? No, I don't think so. Oh, doctored video. We could probably, yeah, we should be able to check that off, although it's going to get worse. There's going to be more about the doctored video in a bit. God, it's unbelievable. Okay, I am on, because I'm on Streamlabs, I don't have my usual videos and stuff uploaded here. And unfortunately, that means that I can't turn on the squats or anything while I have to quick take a, the court needs a, what do they call it? A comfort break. So I'm just going to let you sit here and I'll be right back. Okay, everybody, if you have to go take a bathroom break, do it now. All right, we're back.
In May of 2024, I was provided with a thumb drive and the CD labeled with a Post-it note on my desk. What's interesting is that the CD with the Post-it note on his desk may or may not have been the same CD that he transported in July of 23 because they seem to be labeled a little different.
So I haven't seen this report. Does he say from whom he received that?
I'll finish reading it, but I don't believe he does. No. No, it's pretty vague. It's passive voice, and it's pretty vague. I was provided a thumb drive and a CD labeled with a Post-it on my desk to review prior to testimony, so it does not say. At this time, I reviewed video made available to me, which included video footage of the Canton PD exterior Sallyport. Exterior Sallyport. This video was labeled with a Post-it note on a CD, and it contained a video of the interior of the Sallyport, which was grainy and had a camera vantage point from the front of the Sallyport. I also reviewed the Canton PD driveway footage. In review, I also viewed video of the back wall Sallyport camera vantage point. I had not seen this video prior to my May date review. I later learned that this video was provided in an inverted manner. After I reviewed all the provided video, the thumb drive and the CD were returned. It doesn't say to whom they were returned.
This is so nuts.
If I could mark this report as well.
Sure. Do you have an extra copy for me?
I do. It does have one highlight on it. May I show it to Mr. Brennan?
Yes.
Okay.
So you do have an extra copy, Ms. Little?
This is so
I
crazy.
have an extra copy, Your Honor.
I thought Mr. Jackson just said he had an extra.
Oh, I'm sorry.
Yeah. Mr. Jackson, do you have an extra copy?
I think I might.
I've got it right here.
Do you have an extra copy? Is that one clean?
Not clean, but.
No, that was the only copy that I got.
May I approach, Your Honor?
This one has highlights on it. I apologize.
It's okay. Thank you. All right, go ahead.
Thank you, Your Honor. The court asked probably the most important question about this report, which is, who was it that supplied the video or the thumb drives or the CDs to Sergeant Buchanan? Who's at the center of all these Sallyport videos? Who does he say was requesting the Sallyport videos that he was acting as the courier for in other particulars? Every one of those answers is Michael Proctor. So who do we believe most reasonably would have supplied the information to Sergeant Buchanan to review? It stands to reason. Could have been Trooper Proctor. Seems to be reasonable. But I don't know because Trooper Buchanan doesn't say. But that would be another question that would be open to answer if we had an evidentiary hearing. Michael Proctor was receiving the footage directly from DG Petro, dating all the way back to February of 2022. He was the one receiving the footage directly from Buchanan, dating all the way back to the spring of 2022. Michael Proctor was receiving footage from both sources multiple times through the years. Proctor was the one who clearly had possession, custody, and control over the exculpatory footage. It was his, every bit of it. And now let's recall what he said at trial when asked about all this footage, because he was confronted about footage. And keep in mind, Your Honor, when I'm asking these questions, I know none of this.
Welcome, Mr. Coop Raiders. Thanks for being here. We're catching up on the Karen Reed hearings this week, and also we will be watching the Turtleboy hearing as soon as this is finished. And we're probably going to skip around a bit because we don't need to see every single bit of this.
None of it. Michael Proctor lied during his testimony, but he knew that we couldn't impeach him. There was no way I could impeach him. I didn't have any of these videos to impeach him with because we didn't have any of the evidence that had been secured concerning that Sallyport. Question. There's surveillance video from Canton Police Department's Sallyport garage that wasn't turned over, right? Answer. That video was discovered later on and then handed over. That video was discovered later on.
So where in the transcript is that?
I can get you the page and line number, Your Honor.
My guess is Ms. Little can get it pretty quickly.
I'm guessing she
I'll
can.
get to you in just a moment, Your Honor.
June 10th?
It was either June 10th or June 12th, but let me double check.
While she's looking for that, Your Honor, may I proceed?
Please go ahead, yep.
Okay. The only thing it's important to remember from a date standpoint, we'll get the date that he actually testified to this, but from a date standpoint, the only thing that had been handed over at the time that he testified to that was a single video with 42 minutes missing, and a flatbed and the flatbed driveway footage, outside the Sallyport that doesn't show much of anything. It's now been proven, that testimony, that video was discovered later on and then handed over, suggesting there was either only one video or all of it was discovered later and turned over. Both of the clauses in that sentence are a lie. The video wasn't discovered later. It was discovered in February, at the latest, February of 2022, just days after this incident. He asked for it, and he received it, according to Sergeant DJ Petro. And it wasn't turned over either. None of it. But at trial, we didn't have the truth. I couldn't impeach him with this. He made sure that all the footage was delivered directly to him, starting days after this incident. And he controlled it, he hid it, and then he lied about it. That is the definition of bad faith. That is the definition of withholding exculpatory evidence. That is the definition of suppressing Brady evidence. There is no other way to define this. He fooled us, and it's egregious. Is it possible, with all this sort of years-long flurry that we've just talked about surrounding the Sallyport videos, that the actual trial prosecutors were completely unaware of their existence until Proctor testified before the federal grand jury? Is that possible? I suppose it is. I want to give the prosecutors the benefit of the doubt. I do. Is it reasonable? That's another question. To believe that they just knew nothing about this. We know Proctor lied to us. Could he have lied to them? I suppose. But as the law mandates, Your Honor, it just doesn't matter. In the eyes of the law, Proctor is the prosecution, and the prosecution is Michael Proctor. And then we move to January 28th, 2025, this year. We're still getting additional videos at that time. This new camera angle, which is blurry and grainy and wobbly.
I want to go back for a second because that is so important, what he just said. This is so important. Let me slow him down.
Doesn't matter. In the eyes of the law, Proctor is the prosecution, and the prosecution is Michael Proctor.
Yes. In the eyes of the law, Michael Proctor is the prosecution, and the prosecution is Trooper Proctor. You cannot separate the two. He was the lead investigator on the case. He did so much damage by doing a shitty investigation. This case should be thrown out.
And then we move to January 28th, 2025, this year. We're still getting additional videos at that time. This new camera angle, which is blurry and grainy and wobbly, it does, however, show the passenger side rear taillight as it's towed into or driven into the Sallyport garage. The footage is so grainy and so blurry, however, it's so corrupted that once again, the true condition of that taillight is completely obscured. At a certain point, it begins to defy logic. And the reason I wanted to talk about each one of these videos in turn is because it absolutely defies logic that all of this footage magically cuts out, blurs out, becomes grainy, becomes obscured at the precise time that the SUV is pulled into the Sallyport.
Very convenient.
Becomes, what's been happening to these videos that have been in Michael Proctor's possession since that time, for the last 2.5, 3 years? And again, I've lost count how many times the Commonwealth makes the claim, quote, prosecutors have never seen this video, end quote. The entirety of the Commonwealth's defense on this issue is the indefensible, which is, it just wasn't me. Okay, fine, it may not have been you, but it was the Commonwealth, in quotation marks, capital. The Commonwealth then claims that, quote, after directing a review of all physical evidence and data files, this video was located within a paper case file of the investigators, end quote. I believe that Mr. Brennan, when he came on the case, he's the one who directed a review of all physical evidence and data files. I would have to guess. Again, I would applaud that. Should have happened years ago. What's most curious about this video, however, is that the prosecution now admits, quote, after inquiry it was learned that an investigator obtained this video from Canton Police Department in 2022, and it was placed in a physical case file, end quote. That's a direct quote from their opposition. They don't name who the investigator is. They don't indicate whose case file it was. They don't tell us where that case file had been, who had control over that case file. Just
no chain of custody.
Mysteriously. Whether it was CPD or MSP, we don't know. Which investigator, we still don't know. What can we learn from this admission by the Commonwealth? That investigators did, in fact, download the Canton PD videos in 2022 before they were overwritten. That's the only way these videos could exist. We've talked about that. And what we don't know is where the rest of them went and why we don't have them. and why we didn't have them for the first trial. The Commonwealth basically concedes that it is in direct violation of its discovery obligations not to have turned over these videos that were in their possession. But it makes the claim that it doesn't matter because, quote, the poor quality of the video makes it difficult for either party to benefit from the video, end quote. In its opposition, it sounds like more of a desperate argument than anything else that these egregious errors don't justify the court taking any action because they claim, quote, there's no evidence of bad faith. I would take issue with that. But the quote goes on, there's no evidence of bad faith on behalf of the Commonwealth, nor any of its agents, particularly where the Commonwealth is equally aggrieved by the poor video quality and inability to obtain a forensically extracted copy of the surveillance video. Equally aggrieved. First, in that sentence, the Commonwealth admits that the defense is aggrieved. They say they're equally aggrieved, however. Aggrieved means wronged, or unfairly treated, or suffered harm,
right,
or injustice. Merriam-Webster defines aggrieved
Throw it
as
out.
suffering from an infringement or a denial of legal rights. You bet we're aggrieved. But the Commonwealth can't claim that they're aggrieved when they're the ones doing the aggrieving.
I mean, even the jury, this is so stupid. Even the jury, the first jury, believed they acquitted on 2 counts, right? The murder count gone. They were split on the manslaughter. Even if they believed, and even if you believe that she accidentally hit this man with her car, is this worth the Commonwealth's time and money to try her twice? Are you telling me that there aren't violent, intentional killers in Massachusetts and Canton to go after? How is this a good use of taxpayer money? If no one believes that she did this intentionally, if she did it, no one believes that it was intentional. The jury is very clear on that. They think that she accidentally hit him if she hit him. So why are we doing this? Is it really going to bring justice to John O'Keefe? Let's say she hit him with the car. Is it really going to bring justice to put his girlfriend in jail for accidentally hitting him with her car in a snowstorm in the dark? They are treating her like she is Charles Manson. It's absurd. It is absurd. It is the most absurd thing I've ever seen. And the only thing that explains it is that other people are to blame for this. Cops. And they have to hang it on her. You know what's really stupid, though? Why the hell didn't they just blame the snowplow driver? Because that wouldn't be a manslaughter charge. It'd be like, well, he probably wasn't seen in the dark. He probably got hit by the snowplow. We're not sure. You know, I mean, this is having to frame her for it, or it is just, there's something so wrong about this. There's something so wrong about all of this. This is what the state of Massachusetts decides to spend its money on. Locking somebody up for manslaughter for accidentally hitting her boyfriend in a snowstorm. Maybe. Like, and there is just no proof of any of it. It's just gross. I do not understand this case at all. It is ridiculous. Absolutely insane. Okay, so there's nothing else. He's almost finished. And then the state's going to get up and give his explanations of things. I think he starts with, I'm running out of time. So what I want to do is go to the part where we're going to skip over Brennan's stuff until he puts up the videos, because this gets real interesting right here. He starts to say, well, it doesn't matter if we gave the videos or not, because the videos don't show anything. And what they actually show is that the tail light was completely destroyed. And you can tell because it's white instead of red. So that means the red cover's gone. But here's an interesting thing. The video is so bad, you can't tell what you're looking at. So you can see it either way. You can still see red or you can still see white, depending on what you think. I'll make myself smaller and this bigger so you can see it. But, thank you, Caroline, for the 10. It says, Megan deserves minimum wage. Be careful of BP. Thank you. I aim for medium wage. You know, if we hit 9 more super chats in the next 20 minutes, I won't turn on commercials. Commercials suck during live streams. Nobody wants that. Nobody wants that. Any color of super chat will do. Super stickers don't count. I don't know why. It's just something that YouTube does. So send super chats if you like the coverage. Okay, so what I was getting at here is this next part. he's going to try and tell you that you can tell that the tail light was already completely destroyed because it's shining white through the light. Now, there's some question about this. I have looked it up. And from my research that I have found, it appears that tail lights are always red bulbs. So he's saying that a tail light is a white bulb with a red cover. And if the red cover is gone, the white light will shine through. But I think he's wrong, because from what I have found, tail lights are supposed to be a red bulb and the backup lights are white. There's two bulbs back there. There's the red tail light and the white backup light, because when you're going backwards, you get white lights to alert people behind you. And from what I can understand, and I don't know about her make and model specifically, but most taillights are red bulbs, not white bulbs. So if you're seeing white, it could be going in reverse. I don't know. But he's going to try and convince you of that. Let me make myself smaller, make him bigger so that you can see this.
Exhibit number 2. Exhibit number 2 shows the inverted camera from January 1st, 2022. Now, this
Hold
is
on.
28 days.
We just saw something interesting when that got pulled up. All right, let's take the captions down, shall we? Do you see, and it's fuzzy right here.
I'm going to ask to put up exhibit number 2. Exhibit number 2 shows the...
Oh, it's fuzzy. There. Right here on the right-hand side, it says AI. AI. He's literally pulling up a video, his exhibits, and open right next to it is an AI program. I know you can't see it through here, but there are clear screenshots on Twitter. There's an AI program that is open. And then what we're going to see is that there is another pop-up that says, edit your videos with AI. Can you say doctored videos?
Inverted camera from January 1st, 2022.
There it is. Did you see it clearer that time? Look, home Adobe. It's Adobe. What do you do in Adobe? What do you do in Adobe? Well, you edit things.
Number 2 shows the inverted camera from January 1st.
It keeps, there it is. Now you can see it clearer. AI and Adobe. Two things are open. Yeah.
2022. Now this is 28 days.
What are they using that for?
These Lexus hits the Sallyport area. Now you can see, if you stop that please, thank you very much. On that wall, on that garage wall, there's a 4. It is backwards. This Sallyport video was not doctored by Trooper Proctor. It wasn't altered by Trooper Buchanan. It was in existence well before Miss Reed's car showed up to that Sallyport. Similarly, front wall camera, could you please put on exhibit 3?
Thanks, Julie. Says Laura Owens did it.
Exhibit 3 is from January 28, 2022, a day before Miss Reed's vehicle makes it to the Sallyport. And you can see the quality. It wasn't distorted.
A day before? Wait a minute, let me get this straight. I thought that the videos all overrode each other every 30 days. How did they have video from a day before? How did they have that? They just happened to have it? It didn't get overwritten? They just happened to have a video from the day before the Karen Reed situation? How? I thought that they overwrote these videos every 30 days. How do they have one that's dated the day before? Weird.
It wasn't manipulation by the state police. This is the way the camera worked in Canton. Thank you very much. So the idea of tampering, we can claim it, we can assert it without fact, but we can prove it did not happen.
But then why do you have all that tampering software on your laptop? Why do you have all the AI software on the laptop?
Now, what we know is that missing taillight was not tampered with because it was gone hours before police even touched Miss Reed's vehicle. At 5:08 a.m., she left Meadows Road. That's John O'Keefe's home. And when she left at 5:08 a.m., that taillight part was already missing. If we look at Exhibit 6, please. And this is from the Ring video of John O'Keefe's home.
All right, what are we looking at here?
Evidence.
What was that? I feel like that was probably important. What are we looking at there?
This is from the Ring video of John O'Keefe's home.
All right. Sallyport, 12822. I bet these are important for some reason. I think that's what Aiden had. I think that's the screenshot he had on his article.
Evidence directly contradicts the idea that the Sallyport video is relevant to show any break or planting of evidence. As Ms. Lee nudges into Mr. O'Keefe's car, she will pull forward and we'll stop the video in two spots so you can get a clear look of that rear tail light missing. Forward, please.
I don't see a missing tail light.
And then ahead one more. You can see the white light shine. Stop. You can see it clearly missing.
I don't see it. It is not clear to me that anything is missing. It is not clear to me. It could be a reflection from this light over here on that shining brighter. It could be something they did to it. I cannot see anything. It looks red to me with a reflection.
That's already gone.
Now, I don't think so. That is not clear evidence that it's already gone. I can't tell.
And the reason why you see white, it is a red taillight cover, and when the red is missing or gone, as it is in this case, the white bulb still shines, and that's why.
Yeah, see, according to my research, though, Google tells me that taillights are you use a red bulb, and that the reverse lights are the white bulb. And I think that I mean, how do we know this isn't doctored with all the AI shit they have on the laptop? I don't believe it.
The defense position is also contradicted by the ARCA witnesses.
All right, so here he's also going to go to this one.
Impacted by snow. If you could close.
Oh wait,
more close up,
hold on, we got to back up. Look at this.
If you could
look at
close
this.
the court, please.
What's that just popped up? Edit your images using AI. Perfect your images or transform them into something brand new. Look what just popped up on the prosecution's laptop. The hell is this? Jonathan Dean, thank you so much for the super chat. Thanks for the 5. Jonathan says the timestamps are different in the video presented in the video they presented at trial. Yeah, I saw that on Twitter, which is, look at this, you guys. Look at this. I mean, this is all I would have to see to be like, no, I don't believe any of your evidence. Case dismissed. This is so stupid. This is the dumbest thing I've ever seen. Prosecution says, we didn't doctor anything, puts up his own evidence, and it's got AI doctoring software popping up on it. Holy crap. All right, we got to get over to Turtleboy's. This is enough. If you guys want to go, and if you want to see the rest of this, obviously it's on Court TV, but that's all I have time for on this one today. Let's go over to this one instead. Which one? I got to get rid of that. Get rid of that. No, get rid of this. Here we go. Okay. All right, this would be Turtleboy's hearing. We're going to start right at the beginning because this gets immediately funny. Like, it's immediately hilarious. All right.
And then I'll throw out at the beginning, and maybe both sides can answer. I'm going to start with the defense, and then I'll go to Mr. Clatchwell.
For those of you who don't know, Aiden Carney, also known as Turtleboy, is a journalist, has a YouTube channel. He is being charged with witness intimidation for his brash, protests and for calling a couple of the witnesses. I think he called Colin Albert. When I first heard it, when I first heard the phone call to Colin, I thought, that's a little much, Aiden. He's saying, I'm going to beat your ass. Bang, bang, and all this stuff. And I'm like, gee, that sounds like a threat. And then it turns out that he was just repeating Colin's words back to him. And, he is in your face. Aiden's in your face. but he's no more in your face than a lot of reporters that I've seen out there. And I don't think anything he's done is beyond freedom of speech. And now he's picked up a new charge, and wait till you see what for. It's hilarious.
Mr. Kennedy certainly a journalist. He's a satirist.
Satirist. You can check off satirist.
How far can you go to satirize things?
How far can you go to satirize? I think are we volume boosted? Let me boost that up a bit. How far can you go to satirize is the question. That's a very good question. Satirist, by the way, I just got bingo. I'm at bingo. Awesome. See, I got bingo. Proof. All right. Let's see. How far can you go in America?
And when does it become a crime? I asked that to Mr. Proctor as well to address. How does the conspiracy counts, which are 14, 15, and 16, how do they fit into this, and how is that intimidation? Are there people that are mentioned in these indictments who are non-witnesses, specifically as to counts 5 and 15? Tell me, Mr. Breda, what do you think that the motorcade, how does that fit into this? Where is the intimidation there, Mr. Croswell? You can obviously speak to that, but Mr. Breda, I'll start with you.
Thank you, Your Honor. You know, as usual, Judge, you cut right to the point, and I appreciate that. You know, we have about 75 pages between counsel and I, and I'm happy to answer those questions. The first, where do you draw the line thing, Judge?
Yeah, where do you draw the line?
Sure.
So he's a journalist. He's got his blog. He's got the website. I'm sure he gets a lot of activity, and he's covering a case. So he's acting as a journalist. But how far can he go?
Sure.
You know, and I say this to Mr. Croswell maybe as well. How about Michael Moore or somebody like that, or somebody who's a satirist in some way, or is trying to bring attention to a certain thing? How far does the First Amendment go in their protections? Go right ahead, Mr. Breda.
Thank you very much, Your Honor. Judge, it is actually a clear line. It's O'Brien v. Borowski. Okay, Judge, I know you're all over this. O'Brien says that all of these strictures that talk about speech and distress and everything else, it's limited to true threats and fighting words. O'Brien says that. Watts in the Supreme Court says that. This is just well-settled law. It's unquestionable. So it has to be true threats or fighting words when the issue is speech. And that's what we have here, we contend, is this is just Mr. Carney's speech.
How about if he says words to the effect I'm going to ruin your life? Is that enough?
No, it's not enough,
Okay.
because it's not a specific threat in terms of any criminal behavior. And that actually is specifically addressed in O'Brien, and it's Snyder v. Phelps, Judge, Snyder v. Phelps. That's the Westboro Baptist Church case where they picketed a dead soldier's funeral. I mean, the most repugnant stuff you can imagine.
Yeah, that is the most repugnant stuff you can imagine. And guess what? It's free speech. You know what? You know what the answer is to the Westboro Baptists who come to soldiers' funerals and they picket with really horrific signs? It's more free speech. You know what happened when that what we did when they did that at my cousin's funeral, who was KIA in Afghanistan? Because they showed up to that funeral as well. We had the Freedom Riders show up as well, about 300 of them, and they drowned them out with their motorcycle engines. It was beautiful. It was the most beautiful thing I ever saw. Frankly, I'm glad they were there. I'm glad that the Westboro Baptist Church showed up, because they got met with a huge force of Americans who said, not on our watch, you don't. You're not picketing this soldier's funeral without a response. But the response is not to stop the speech. The response is never to stop the disgusting speech, even if it's disgusting. The response is more speech. Yeah, the Freedom Riders are really something. The Patriot Riders, the Freedom Riders, they are really something. And they were out there in 112-degree Oklahoma heat, wearing their leather and everything, 300 strong. It was awesome. And they got between the family and the protesters, and they did not allow it. It was just beautiful. And all we had to do was ask. And they showed up. They never asked for a thing. And it is important in this country that we do not imprison people for free speech. And nothing Aidan Carney has done even comes close to being as disgusting as Fred Phelps. Not even close.
But it's inflicting emotional distress in public on a matter of public concern is protected. So,
yep.
And O'Brien specifically talks about that the fear needs to be defined. It's fear of property damage or being a victim of a crime. It's not fear of being sued. It's not fear of being embarrassed. It's not Ms. McCabe in Stoughton District Court saying, is there any way you can get him to stop blogging about me, Judge?
Exactly, which is why this case right here is very similar to the Hales case, right? Very similar. We've got you fear of embarrassment, and being embarrassed or, shamed online is free speech. You can't complain about that, which is why the idiot lawyer, BBB, who's defending Lynette Preston, who keeps on accusing the press of harassing her by mocking her deposition, her totally mockable deposition. It's the most mockable thing you've ever seen. He's wrong. He's 100% wrong, because you are not free from embarrassment in this country. If you embarrass yourself and the media mocks you, or social media mocks you, that's just the way it is. We have free speech. You're getting mocked online is not a reason for you to go say you need to arrest that guy and put him in jail. And that's what they're trying to do to Aiden Carney.
Walsh. That's not the fear we're talking about.
How about calling in phony pizza riders at a pizza restaurant?
I'm glad.
How about calling in and phoning in pizza orders? Oh my God. Oh my God.
Brought that up too. There's no evidence whatsoever, and he didn't do that. Mr. Carney did not tell people to do anything with respect to that. But more to the point of our motion here today, there's no evidence of that. I don't want to say.
Yeah, okay, this is exactly like the Jeremy Hales case. So she is claiming, Preston is claiming, people are calling social services on her. False calls to social services because of Jeremy Hales. There's no evidence of that. First of all, there's no evidence whatsoever of that. The only evidence we have of anybody calling CPS are neighbors and friends and people who know her personally. There's no evidence except for one person that we know of, Vet Nation, who did it online. But you cannot say because somebody watched Jeremy Hales and then they went and did something, like made a call to CPS. That is not Jeremy Hales' fault. And if somebody watched Aiden Carney and then decided to make prank calls to a pizza parlor owned by the Alberts, that's also not Aiden Carney's fault. None at all. It has nothing to do with him.
It sounds sneaky when when I say, there's no evidence of that. He didn't do it, A, and B, there's no evidence of it, and that's what we're here for, is to look at the evidence in the grand jury. There's no evidence whatsoever that he told anybody to inflict economic harm on the guy. Even if he did, which he didn't, how is that a crime? It might be something he could be civilly sued for, but it's not a crime. And
right.
But the most important point on that, Judge, is that he didn't do it, and there's no evidence of it. That points up something that we want to address as well, Your Honor, is the idea that there's so much imputed derivative liability infecting these grand jury minutes. It's ridiculous. It's as if the Commonwealth just basically forgot about the notion of joint venture and just wanted to attribute every bad thing that has happened to any one of these complainants to Mr. Carney. I'll give you a ton of examples. Proctor says people drove by and spit on my lawn or whatever. That's got nothing to do with Mr. Carney. They have no evidence. He said, hey, let's get into joint venture here for you to drive by and spit on his lawn.
What's with the cameraman?
Mr. Carney. Another example that should throw out the entire case is McCabe. Jennifer McCabe says, I got an email that someone was going to rape me on my front lawn. That has nothing to do with Mr. Carney. The fact that there are other people, many of whom are in this room supporting the First Amendment and supporting Mr. Carney, that are concerned about this and that speak out, Mr. Carney is not responsible if they cross some line.
Right.
It's not his cross to bear.
Right. You cannot hold me responsible for something that somebody in my audience goes and does that's illegal. I'm not responsible for that. The person who did it is. So if somebody is sending messages threatening Jen McCabe, that person is responsible, not Aiden Carney.
Your Honor, if the government wants to make a joint venture case, let them try, but they certainly haven't here. And that's the most important point, is that all of these derivative liability things, you got to throw those out the window, Your Honor. You can't use them as a basis to uphold an indictment, but also there's no evidence of it. There's no evidence that he did anything wrong. So all those derivative liability things, Judge, I hope that, I know you've looked at everything. When you look at it again, it can't apply to Mr. Carney. It's just not within the law. It's not even, Zanetti, defense lawyers talk about Zanetti all the time, about how broad it's become.
Oh boy, we missed the goal for the very first time. I can't believe it. I'm going to have to turn on commercials. Well, it is what it is. Just turn it on. But thank you, those of you who did. I appreciate it. And let's see. Okay. And if you want me to turn them off, We can always do 10 more. We can do 10 more and I'll turn them off. How about that? All right. I don't know if it'll let me do it or not. Will it let me set one? All the colors. We'll do 30 minutes. Yeah. Okay. That should work. Huh. I don't know. The goal thing isn't working all of a sudden. I'll have to refresh the studio and see what happens. But meanwhile, we'll just turn the commercials on. That's the wrong one. Let's see. I got to go over here.
It doesn't even come in the galaxy of Zanetti. There's no evidence that Mr. Carney urged anybody to call the pizza man and, order things and not show up. There's no evidence about the Proctor thing. He's got nothing to do with the Jennifer McCabe emails. All these things, Judge, are the government's attempt to just throw enough mud at him so that a judge who's swamped with these things says, there's all these allegations. I know you're not going to do that, and that's why we're here in front of you, is because we have every bit of faith that you're going to look at this in the way that it needs to be looked at, and that you're going to look at it on the right side of the First Amendment, Your Honor. The derivative liability stuff's got to be out the window. Okay. Can you refresh my memory on your next question, Your Honor?
I think I had asked a couple of questions, one of which was where is the line, the conspiracy, which I think you talked about.
Yes.
And then the motorcade, which you talked about as well. How about the one of the people who, in counts 5 and 15, who are at least, it's the same person, but it's intimidation of a witness. Is that person a witness?
I just don't have it in front of me, Judge, in terms of 5 and 15 is the allegation. Elizabeth Proctor, yes, she's not a witness, but the breadth of the witness intimidation statute, Judge, does cover family members of a witness. Okay. So I'm not taking issue with that, but it just goes through every single one of these. It doesn't rise to the level of threats or fighting words, Your Honor. Okay. It's just, and the other huge issue that the Commonwealth ignores and just wants to look the other way and go after somebody out of their own self-interest, and we'll get to that later, but it's this notion that political hyperbole is somehow off the table. So I'm going to rewind a little bit, and that's the Watts case. It goes back to 1969, Your Honor, when a guy who was speaking about the draft, and he said that if they put a rifle in my hands, the first person I'm going to get in my sights is the president, LBJ, Lyndon Baines Johnson. And he was prosecuted under the federal threat statute. And the Supreme Court, they laid it out very clearly. This is called political hyperbole. The context, the distance, the First Amendment aspects of it, it's political hyperbole. It's not really going to happen. It's something that a First Amendment protected speaker says to underline their point, to underscore the force, the rhetorical force of what they're saying. So that principle, Your Honor, is sort of the foundation for a lot of the case law that we cite in the brief, and that, it's
political. So words to the effect of, I'm going to destroy someone's life, or I'm not going to let them lead a comfortable life.
Right.
So that's what your argument is, that even under that case law, which is obviously
controlling.
Different, but yeah.
Controlling, Your Honor. I think the word you're looking for.
Yeah, well, that might be your word, but I'm saying that,
it's the Supreme Court, and that's another issue we want to talk about, judges. The Commonwealth of Massachusetts just forges ahead with this ridiculous statute, this witness intimidation statute. If that statute was passed in 1775, every single one of those legislators would have been pulled out of the State House and tarred and feathered on Boston Common. That statute is ridiculous, Your Honor. It talks about inflicting economic harm, inflicting emotional harm. I think someone's going to receive emotional harm if they hear speech that says, "You're a liar, I'm going to sue you." Under the statute, that's a felony.
Yeah.
In Massachusetts.
It's a stupid statute.
Not in the rest of the country, anyway. Not under the Federal Bill of Rights and the First Amendment, but apparently in Massachusetts and the North.
And that's an interesting point. Any law that contradicts the Constitution of the United States is moot. Any law that goes against the Constitution, which this one totally does, it's not relevant. You cannot hold someone to an illegal law. It's illegal.
In Norfolk County, it is.
Okay, let me turn to Mr. Cosgrove. I think you've answered that question.
Thank you.
Let me turn to Mr. Cosgrove. Mr. Cosgrove, maybe, so some of these counts, I mean, there's obviously a lot.
What is with the cameraman?
But going to count 8, which involved a member of the state police, where he's walking out of the courthouse here, and allegedly the defendant directs the attention of certain people towards him, and then they chant and they call him names. Does that rise to the level of intimidation of a witness?
I think that's probably the one closest to the line, Your Honor, candidly. But if you look at the testimony and if you view the video, you'll see that He's pursued down the street. He's shouted. He's approached by people accompanying Mr. Kearney with
Yes,
cards
void.
that they're waving and
That's
so
the word I
forth.
was
And,
looking for.
I certainly think he could have legitimately feared for his safety. The fact that he's a rather robust gentleman and that there are other police officers around might mitigate that fear, but I don't think it was totally unfounded.
Okay. Well, but some of my other questions, just, as we get into these specific indictments, as to the indictments that are at the end of the 14, 15, and 16, they talk about the conspiracy with the person who evidently worked for the police department to get license plates and puts them out there. What's your theory on how that amounts to intimidation of the witness?
A conspiracy to intimidate a witness?
Yeah.
Which is a little different, as Your Honor knows, from the actual intimidation.
Yeah.
There was testimony that this person had done this sort of thing for Mr. Kearney before, that she was familiar with his online activities, and that she knew that what was likely going to happen when she turned over this license plate was that it was going to be used to dox the witness. So I think.
By the way, I saw Aiden talking about this last night, I think it was, and he showed proof that in multiple investigations he's done in all different types of stories, he has asked the public to run a license plate for him. So he has used Twitter before to say, hey, I need this. Anybody can somebody run this license plate? I want to know who this is. He used to do an entire series on people parking in handicap spots without handicap stickers, and he would expose them online for parking in a handicap spot. There is nothing illegal about this. There's nothing illegal about doing that. And, he didn't mention what the plate was for. What had happened was he saw a car that he thought was Jen McCabe's car parked in front of one of those cops' houses. And he wanted to verify that it was her car. So he asked, again, the internet, can you run this plate for me? Because he wanted to know whose car it was. So this is something, though, that he's proven he's done before in other cases, lots of them. Was it Proctor's house? Yeah. Wicked Sykes says, we all knew whose Jeep it was, but we wanted confirmation. Did he get that confirmation? Was it her car? And it was hers. And it's not, I'm sorry, but that is not, witness intimidation is, you testify this way or I'm going to hurt you. Show me proof that he's ever said that about anybody. Protesting certain witnesses, protesting the police, protesting these witnesses, that is not witness intimidation. That's ridiculous. Absolutely ridiculous. So they're trying to make a case that he conspired with someone to dox a witness online. But really, you're not doxing anybody to say that's her car. That's not doxing. And by the way we view doxing, by the way we see it on the internet is that it's rude to put up somebody's personal information online, but it is not illegal. It really isn't illegal. Your address is actually a public record, and anybody who knows how to search public records can find it, which means by definition, it's public. We don't do it because we think we shouldn't do it because it might put someone in danger, but it's not illegal.
I think that's the essential theory. And there was also a suggestion, as I recall it, that she herself had some interaction with Mr. Kearney in the past in connection with a niece or something like that, and didn't want to get on his bad side. And I would suggest there was a reason that she didn't want to get on his bad side.
Okay. As to some of the counts that go into the motorcade, where it goes to different people's houses with a motorcade of followers.
The protest?
Of Mr. Kearney, are you suggesting that he's acting as an individual or he's acting in some sort of a joint venture?
Well, I think the evidence would certainly support joint venture. Essentially, there was evidence that Mr. Kearney planned this motorcade, that he broadcast what the location, the gathering point was going to be, that he showed up.
You mean he planned a protest? How dare he? This is America, sir. We're allowed to protest, including in front of police officers' houses. My understanding is they spent 2 minutes in front of these houses and kept driving. 2 minutes.
With a bullhorn to address the crowd.
Well, what?
He had his cameraman, or perhaps it was he himself with his...
How about you tell me how you feel about the Supreme Court justices' houses being protested and having rave parties out in front of their houses in a private neighborhood at 2 a.m? How about you tell me how you feel about that? So what?
His phone to film the events for a later broadcast, that these people proceeded at his direction to the various locations. Only the first location was announced in advance, so they got there by following him. And when he got there, he got out of the car, and
oh no,
statements varied somewhat from location to location. But
he got out of the car on a public road and said some mean things in a bullhorn. Oh God, lock him up.
Harangued the occupants of the house.
Oh, harangue? He harangued. He harangued the occupants. This is America, sir.
As to...
so let me ask you about count 2. So count 2 talks about intimidation of a witness, 25 to 30 people, Mr. Kennedy with a bullhorn telling a witness to tell the truth. How is that not free speech?
Well,
yeah. How is it not free speech?
Ms. Nagle, count 2.
Well, I don't want to sound like Bill Clinton. It depends on what the meaning of is.
All right.
But
well, that's embarrassing. If you have to say, I don't want to sound like him with that ridiculous, it depends on what is, but I'm going to do it. Depends on what is. That's an embarrassing position, sir.
In the context of Mr. Kearney saying, tell the truth, I think the witness would clearly understand that what he's instructing the witness is tell my version of the truth.
Okay.
What? If he said tell the truth, then that's what he said, was tell that he was encouraging the witnesses to tell the truth. And you're going to call that witness intimidation, but you're going to put words in his mouth and say he meant tell my truth. Oh, F off, sir. Off you fuck. That's absurd. They're trying to put this man in prison for saying tell the truth. Wow.
In other words, don't change your testimony or don't testify.
What? In other words? But he never said that. He never said change your testimony. He never said don't testify. He said tell the truth.
Okay. And then how about releasing the phone numbers to the public?
How did we even get here? And releasing phone numbers to the public, remember what I just said. Your phone number is also not private information. If I can find it online, which I can through people finders, through all sorts of things, it is not private.
In your view, does that cross the line, taking the phone number of an officer or of a private citizen and putting that out on his website? Is that something that you think is protected speech? Obviously, Mr. Bradle does, but from your point of view, does that amount to intimidation of a witness?
I think there's a distinction between your ordinary, if there is such an ordinary thing, as putting somebody's phone number on a website and doing it to a witness in a criminal case with the intent to intimidate that witness. And I think this also relates to a comment that Mr. Bradle made. From the defense perspective, the court is to look at this with a very limited lens. Just look at what Mr. Kearney did. Don't look at what else happened. The fact that Mr. Kearney said, throw a rock or show up for an exhibit, or and that's a hypothetical, or show up for an event, or here's the phone number, go ahead and call. Well, he's not responsible if what results from that are a ton of annoying phone calls, obscene phone calls, etc. But I would suggest that that's the intent, clearly, that the grand jury could find in posting that, and that's the practical result of what's being posted. And the intent further is to harass and intimidate the witness.
Okay. Anything that you want to say that you haven't said already, Mr. Cosgrove, in support of your position? I know I started off by asking questions, but if you have anything that you want to direct my attention to,
sure.
Or you think it's important, I'm happy to listen. And I'd like Mr. Bradle the same opportunity. I've read everything that both of you have submitted. Let me start with Mr. Cosgrove, and I'll leave you.
I'd just say a couple of things. First, I heard Mr. Bradle say there was no evidence of this and there was no evidence of that. And with due respect to my brother, I think he's making a layman's mistake in his characterization of evidence. When a witness testifies that I was watching a YouTube presentation and I heard Mr. Kearney urge people.
What's going on in the Commonwealth? Why do they call each other brother and sister? I heard that Jackson said that too. My brother here said. Are they referring to officers of the court as their brother or sisters? Is that like a Commonwealth thing? He's not discussing his biological brother, is he? What is happening?
To order pizzas and not pay for them, that's evidence. Now, grand juries can believe it or disbelieve it. The defendant can contest it in court if that same evidence is offered in court. But the fact is, it's evidence of what happened. So I don't think the statement that there is no evidence is accurate.
Oh, the city of brotherly love.
Your Honor, the difference...
I got it. The city of brotherly love. Yeah, Philadelphia, right? No, that's Philadelphia. That's not, we're in Massachusetts. What do they have to do? Do they just do this? Are they like, it's like they're brothers and sisters of the bar? Huh. Just a Massachusetts thing? Yeah, Massachusetts, it's weird.
Between Mr. Bradle's position on behalf of Mr. Kearney in the Commonwealth is that when you ask, where is the line? Yeah. Mr. Bradle's position is essentially there's no line. The Commonwealth...
No, what a lie. Lie. The line he said was fighting words or threats. Actual threats and fighting words. Those are defined in the law, sir.
Whatever might be the case, there's two lines of cases. There's the line that Mr. Bradle is relying on here. And he suggests that to be consistent with those cases, which talk about imminent harm and which talk about threats being made to the person's face and threats of bodily injury and so forth, that this statute must be unconstitutional and that it is to be construed consistent with these civil cases that he cites. And both of the cases that he mentioned are civil cases. The Commonwealth's position is that whatever the position towards the general public, and I alluded to that earlier, the courts have said that restrictions are possible when there are reasonable limitations as to time, place, and means. And we see that in a number of ways in cases that have been approved by the courts. Cases that have recently had an approval of Judge Cannoni's order with respect to picketing in the Karen Reed case. That wasn't held as an unconstitutional violation. We have decisions in 209A orders where judges order, and I'd cite the court to the case that I didn't mention in my brief, Commonwealth versus Butler. What happened in that case, I think it's fairly well known. Your Honor may be familiar with it. Young woman on the day of her birthday went to her door and found some flowers that were anonymously delivered. I think we'd agree that if you send somebody some flowers on her birthday, that communicates typically a message. Hopefully the message it communicates is happy birthday. Unfortunately for Mr. Butler, about 3 months earlier, the court had entered a 209A order, no contact directly or indirectly. They traced the flowers back to Mr. Butler, was prosecuted, found guilty, the conviction was upheld. That sort of thing happens on 209A orders all the time, which ostensibly you could look at on their face and say, oh, this infringes on my right of association. This infringes on my right to travel. This infringes on my right to make witty satirical statements. Nevertheless...
But Mr. Kearney is a satirist. I mean, in essence, a lot of this is satire.
Well, I don't mean to be flip, but so what?
Okay. No, that's fine.
I don't think there's a special rule for satirists if the so-called satire is made
yes,
with
there is.
Intent to...
No. Yes, there is. Satire and free speech are protected. So unless it's fighting words or actual threats, then yes, there is a special category. And the judge is like, I get your point if the intent is to intimidate. What?
Okay, that makes sense. Yeah, I see your argument.
I'll stop at this point.
That's fine. I'll give Mr. Brady. I'll give you just a minute. I do make your argument pretty well, but anything else you want to say?
There are some things, Your Honor. I just invite your attention to pages 9 and 10 of my brief, Judge, where the standard of how this speech is supposed to be judged is set forth. And just a couple of quotes. Speech on matters of public concern is at the heart of the First Amendment's protection. Speech concerning public affairs is more than self-expression. It is the essence of self-government. Speech on public issues occupies the highest rung of the hierarchy of First Amendment values and is entitled to special protection. The Commonwealth is arguing the other way around. Give us the benefit of the doubt, Judge Doolin. Hey, evidence can be construed in different ways. Evidence needs to be linked to a particular person committing a crime. That's what they're lacking here, Judge. And this Janelle Webb conspiracy to run a license plate business, Your Honor. The Commonwealth indicted Ms. Webb, and then, for some reason, and I think I know the reason, thought better of bringing the case to court and never arraigned her, never charged her, never did anything with that indictment, which I've never seen in my time. And I think what happened there was that the government, the state police probably realized that, hey, they run these plates on the sly all the time for boyfriends, girlfriends, et cetera, et cetera. And they don't want in the system a precedent where a police affiliated person, quote unquote, runs a plate and then gets indicted for a felony.
No,
I think that's why that never saw the light of day. So there never was any conspiracy charge lodged against Ms. Webb. It's past the year presumptive speedy trial. So that case is effectively dead, Your Honor. That's a
Well, how can they even bring it up?
And also, it's not a crime to run a plate. So there was no criminal object of the conspiracy to run a plate. They just want to change, they want to erase the word conspiracy to run a plate, and let's put something in there, even though there's no evidence of it, let's put something in there that'll fly, like conspiracy to commit witness intimidation. There's no evidence whatsoever that 13B was implicated in any running of a plate. In fact, it's quite the opposite. It couldn't be more newsworthy. The district attorney had just gone on television with a remarkable statement vouching for witnesses in his case, that they were fine, they were on the up and up, and leave them alone.
That, but in terms of, so you're under indictments 14, 15, and 16. Your argument is that there's insufficient evidence for those to actually be a crime.
There's no criminal object, and even in the grand jury, Sergeant Tully admits, and he says that it's not a crime, it's an.
Do you see the woman behind him? Look at Aiden's faces on her t-shirt.
Administrative violation. He says words to that effect. You'll see it. And he does refer to that, and it's not a crime. That's why they couldn't say conspiracy to run a plate, against the rules, because it's not a crime. That's why they switch it to conspiracy to intimidate a witness. It's not intimidating to prove the exact opposite of what the district attorney said publicly, that these witnesses are affiliating with the state police and do know the state police and are visiting them at their home. So it couldn't be.
It is not intimidating to prove that the prosecution is lying to everyone by saying that the witnesses aren't affiliated with one another when Jen McCabe's truck is outside of Proctor's house or whoever's house, whatever trooper she was visiting that day.
More newsworthy, Your Honor. And that's what was behind running the plate.
It's absolutely newsworthy. Absolutely. 100%.
Not to intimidate anybody, but to shine the light of day on corruption. Okay. So that's that. And Judge, another thing about this First Amendment issue, and whether it's a jury question or a judge question, this is a judge question. You're not the
crap. I'm running out of time. All right. So I will go over more of this in detail. I'll do another stream on this because I do want to finish the Turtleboy hearing. I actually haven't heard the whole thing, but I will tell you they have added another charge. They've added another charge of witness intimidation for this. Now, this is so absurd. I can't play it. There is no, as far as I know, there is no audio to this. They claim they have an audio, but we haven't heard the audio. People are putting music to it because it's so funny. Hang on one sec. Wait. Don't play the music. No, stop. I'm going to get copyrighted. All right. Aiden, not a wise move necessarily, but just messing around, is at a bar in Canton, has a few drinks, goes to the pizza parlor. There's nobody there, to Albert's Pizza Parlor, looks in an empty window and starts goofing around with a friend. He calls it grab-assing. They have now added a new charge for witness intimidation against Brian Albert for this video. Look at this. They're just joking around. Now, they're claiming, he does say what he said. He said there's no threats in here. He's just messing around. When nobody is there, nobody's there. Look at the guy behind him. He's laughing so hard. He looks like he's going to pee his pants. Sorry, Chris Albert. What did I say? Whatever, Albert. At the pizza shop. Look at this. Does this look like witness intimidation to you, or a couple of guys who've had a couple who are messing, just screwing around and having a laugh? How is this intimidating to anybody? But he got another charge now. They're charging him again. I don't know who the glarer is. Who's the glarer? I don't even know who that is. So, I mean, this is insane. And if you want to, you got to hear Aiden talk about this, actually. Let's see. I think I have it here. Oh, he plays the music, unfortunately.
And whatever. She just sits there, just Big Red and whatever. I bet you Big Red she has to give good.
He talked about, oh God, Aiden. He's obnoxious, okay? He's obnoxious. But here is a video of, I think, is it Bettero trying not to laugh?
That's not really him reacting to the video. All done. How many?
Oh, no. To the window, to the wall. That's a really funny one. Come on. How is this witness intimidation? How? It makes no sense. This makes no sense at all. So you can't mess around in front of a security camera now in America.
Or whenever I
appropriately
can.
give him a fair and unbiased investigation on anything, and why they continually crop up is unfortunate.
Now, Aiden did make some statements about this video. He said, okay, you can call me stupid. Maybe I shouldn't have done it. You call me like maybe I'm immature. And looking back in it, am I punching myself like for doing it? Sure. But this is not witness intimidation. I don't know where the timestamp is because I forgot to write it down. So I can't do that currently right now at this very moment. But I'll go back and we'll finish the rest of his hearing at another time because I've got to run. Mr. Fox is going out of town, and so we're going to go and have lunch before he does that, and I want to go hang out with him for a bit. So thank you for being here today, you guys. Thank you so much. I really appreciate you, and you guys are the best. And by the way, let's see. So tonight, I should be on with Tug at 8 p.m. on his channel. We will be continuing the deposition reading of Amanda Martin in the Jeremy Hales case. And so I will see you then. And you guys take care.